The only person that was absent, nobody was absent.
Yeah, one was there, yeah.
Okey dokey, smoking. Moving right along. We're good?
Oh, it doesn't work? Oh, that's.
Good evening. I'd like to call the regular meeting of North Branford Planning and Zoning Commission for Thursday, October 1st to order. In attendance are regular member Leskovitz, Galdenzi, and Dulac. Our first order of business are meeting minutes from September 10th and 17th. We cannot do the 17th, but we can do the 10th. Bill, Fran, and I were here. So you want to take a, I don't know if you had a chance to take a look at them.
I did, I didn't have any.
I make a motion that we approve the minutes of, excuse me, September 10th.
I second.
Any discussion? All in favor?
Aye.
Aye. Any opposed? That passes 3-0. Okey dokey. And the next, September 10th ones will table to the next meeting if we have necessary people here for that. Okay, let's see.
That was September 10th they approved it. Was it the 10th or the 17th?
Oh, did I just?
The 10th
Okay.
we
Yeah, the
approved.
10th.
Oh, all right.
I think I just said it opposite.
That's
Yeah.
right.
Okay. Our first order of business was going to be the public hearing for PZ application 2015-7. That was for 1565 Middletown Ave. That's been continued to our next
Oh,
meeting of
okay.
October 15th per the applicant's request.
Right, we have for the record, we have a letter dated September 25th requesting an extension of 14 days from the meeting on October 1st. They have been working with East Shore Health to get some information, and I spoke with Dave Nafis of Nafis and Young, and they are working on the septic system, trying to figure out the appropriate size, and that also has to be passed up to the state as well as reviewed by East Shore Health.
Which one was that?
Mill Pond Tavern.
Oh, okay,
Cedars
gotcha. Yeah,
and-
yep.
Yep.
I don't have a problem with that at all. But did they request an extension last time too? And
They did.
Is there a
Yeah.
limit? As long as they extend it, it's okay? We have the limitation, right? 35 days or whatever.
Actually,
65.
65,
65 days.
right, so they can only extend it for 65 days.
Okay, so, that's
So
what.
we're
it is.
okay right
Yep.
now.
Okay.
They've requested 2 extensions so far.
Right, okay.
Where's 65 take us? What was the start date on that?
The start date was August 6th. Oh, let's see, sorry.
No, I think,
No. The, so we received the application July 9th,
right.
and we opened the public hearing on August 6th. So we did that within this
Right.
first chunk of time, 65 days. Then we can have the public hearing for 35 days, but since you can extend that up to a max of 65 days.
Okay.
So they've done, I believe this is
August,
their
September, October.
3rd extension.
Yeah, so we can go to, so we go to September,
So right now.
September 6th, I'm just gonna throw on there,
Yeah,
right,
sorry.
there's 31 days, I think, in August,
October
but
6th,
So-
roughly.
October 6th is like 1 month. I mean, September 6th is 1 month.
Yeah.
October
Right.
6th would be like 60 days.
So the 15th is
And
good.
but then they extended it to the 14 days, which means they got us, so that covers to the next meeting, so really.
So they have up to 35, we have up to 35 days from August 6th, just per the statute, and then
Right.
they can extend it an additional 65 days.
Oh,
So they
65
should
from that,
have
okay, yeah, gotcha.
9 or
That's fine.
Yeah, but I think the last possible time we can act on is October 15th, right? Because then after that, it goes to November, the first week in November. Because that'd be our first meeting in,
That would still be 95, though. If you have 95 from
Right,
August
so
6th,
it's the
that'll.
35
35 plus
65.
Yeah, but that's the 35 stops once we do the public hearing, and it goes from public hearing to 65.
Right, then we only have 65 days to render a decision and act on it.
Right, so if we started the public hearing August 6th,
Right.
we only have 60 days from August 6th.
No, we have the 35
35 and
plus
60.
65, if they extend.
Oh, I was saying
Yeah,
July 9th was the
100.
first, that was the 35 days to get us to August 6th, I got you.
We're
I
good
got
till
you.
like
All right.
mid-November
But
or
we
something.
could be cutting it close just because of our meeting schedule.
Right.
And in see. November, we're meeting twice, but December we're
December,
only meeting
yeah.
one.
Yep.
So I'll touch base
Okay,
with them
yeah.
before the next meeting.
Just curious.
Okay, the next order of business is PZ application, public hearing for PZ application 2015-8. Yep. And read that.
Yep. So legal notice was submitted, inserted in the Sound on Thursday, September 17th, and Thursday, September 24th, 2015. Legal notice, North Branford Planning and Zoning Commission. Notice is hereby given that the North Branford Planning and Zoning Commission will hold a public hearing at 7 o'clock on Thursday, October 1st, 2015, at the North Branford Town Hall Council Chambers, 909 Foxen Road, North Branford, Connecticut, to consider the following. PC application 2015-8, it's a special use permit request under section 23.1, section Schedule A, line A11, to allow an accessory dwelling unit at 7 Driftwood Lane, map 42, lot 8-1, R40 zone. Owner applicant James and Pamela Vanderberg.
So, seated for the public hearing, do we each one individually?
Yep, gotcha.
Seated for the public hearing is members Leskovitz, Galdenzi, and Dulac. So the first,
Yes, I received the cards. There were a few that the applicant had mailed out, but there's, the post office doesn't have record if they were picked up, but there's proof that it was mailed out.
okay.
And the applicant did go to the zoning board of appeals and received a variance at their September 21st meeting. And the variance was needed for exceeding the 600 square foot requirement of the accessory dwelling. Do you want me to go through the referrals now, or do you want to hear from the?
We'll hear from the applicant
Yeah.
first. Your name and address.
I'm Jim Vanderberg.
Okay.
I'm applying for this application because I'm trying to sell my house to my daughter and son-in-law who live with us. And when we bought the house, everything that is under the application was already there. And they told us it was a legal dwelling, that they had done the right thing. And when it came to the mortgage time, the mortgage company asked for a certificate, and they didn't do it. So they came out and checked it. I have to get a building permit if I'm approved. And I'm just trying to get a process done so my daughter can take over the house.
Oh, so this
Nice.
isn't existing?
It's all existing.
So the 600 square feet is already existing?
Everything is built.
Oh, gotcha.
There's no addition, no nothing, it's just to prove what was done without the permit. They had a permit, but they did other work instead of what was on the permit.
Gotcha. Okay.
Do you have any, you want to go through the, well, what was the, you provided some drawings, it looks like?
Yes, I
So
did.
what was built that wasn't on the permit?
Nothing was built. Everything is there what I bought.
Oh, okay, I'm sorry.
Everything
Yeah,
is just the way I bought it, except for we
Gotcha.
added new windows and doors.
Okay, so now when you go to sell it,
The
you're saying
the mortgage
that-
company needs a certificate that it's an in-law apartment.
Gotcha,
And we've been paying the taxes as an in-law apartment and everything since I bought
got
it.
it, understand. I understand. So I think we can just do the referrals.
Yeah.
The building official said that the property must be able to demonstrate compliance with the current building codes. The town engineer said there are no outstanding engineering staff comments. And then just as a quick comment of my own, so I actually went out to the property, I've been working with Mr. Vanderberg throughout this process. As he explained, his daughter and he live in the same house, but he was trying to just transfer title, and that's when they came across this issue of it not being permitted. So in your packet, what he included is what we have on file. So going back to, I think it's 2002.
I think so.
That's when the town issued a building permit, but it was for the conversion of the lower level to, there was a computer room there, a family room, and I don't know, I don't believe the kitchen was part of it. It was a conversion of the garage. But the point being that it was never mentioned as an accessory dwelling unit, so they never came through planning
Right.
and zoning to document it as an accessory dwelling.
Gotcha. What did the building official say on this referral?
They
Have
must
to
be able to
meet
demonstrate
current building codes.
compliance with current building codes, because we don't have on file a certificate of occupancy for the lower level unit. So he'll have to file a building permit, but he couldn't do that until he went through ZBA and planning and zoning.
And then-
And I saw the unit myself, and it's contained within the home. There's a door that connects into the upstairs
It's a raised
unit.
ranch, and the garage is part of it. The lower part, the lower right of the house is a raised ranch, which is our bedroom and bathroom and computer room. And then there's a door that goes onto the other side of the cellar area, which is a playroom, furnace room. And then there's stairs that goes upstairs where my daughter
Oh,
lives.
okay.
East Shore Health was also included on the referrals, and they just had a comment that if there were any issues that repairs were needed, there may need to be some changes to the
Right,
septic
but they
system.
approve what was there right now.
Once the building permit is issued, then somebody will go out and check it, and whatever needs to be done will be completely different.
Yep.
Gotcha.
And then there was proposed reasons for approval.
I move to approve planning and zoning application. Oh, sorry.
Yeah.
Right?
Yeah, it was
See if
a
there's
thing.
anyone.
Yeah.
Oh, yeah.
This
is a public hearing.
Yes, this is a public hearing. Would anybody like to speak on behalf of this application? Anybody else? All right, so at this point in time, I'm going to close the public hearing. Thank you.
Yeah, thanks.
That's what happens when you don't show.
What about- do you want us to
Yeah.
have a discussion on the numbers?
I will. That I won't forget.
All right, you ready? I move to approve planning and zoning application 2015-8, special use permit accessory dwelling unit, excuse me, under section 42.5.5 and section 23, Schedule A, line A-11, to permit an existing accessory dwelling unit within an existing single-family house, 7 Driftwood Lane, Assessor Map 42, Lot 8-1. It's an R40 zone. Owner applicant James and Pamela Vanderberg, as shown on the submitted application map and drawings, subject to the following conditions. Number 1, conformance to the requirements of section 42.5.5 of the zoning regulations and ZBA September 21st, 2015 approved variance of section 42.5.5.f to allow a 1,056 square foot accessory dwelling unit where only 600 square foot is allowed. Number 2, adherence to all applicable building codes and fire safety codes.
Is there a second?
I second it.
Is there any discussion on this?
No.
Pretty straightforward.
Yep, pretty straightforward.
Since it's a public hearing, it's going to be a roll call vote. And Bill, since you brought the motion up.
Yeah, I vote to approve. Reasons for my approval: the existing accessory space is contained within an existing single-family home and maintains the single-family house appearance.
I also approve, because it provides alternate housing option that enables family members to live together in the same structure and provide additional care and support to one another.
I also approve one is, you have ZBA approval as well, and it was an existing prior to your
Purchase.
original purchase, so that motion, this application will pass 3-0.
Thank you very much.
Thanks.
Appreciate it.
Thank you.
Next order of business for the public hearing is PZ application 2015-10.
Yeah, so again, the legal ad was placed in the sound on Thursday, September 17th, 2015, and Thursday, September 24th, 2015. Legal notice, Branford Planning and Zoning Commission. Notice is hereby given that the North Branford Planning and Zoning Commission will hold a public hearing at 7 p.m. on Thursday, October 1st, 2015, the North Branford Town Hall Council Chambers, 909 Foxton Road, North Branford, Connecticut, to consider the following. And it was letter B. It was PEZ application 2015-10. It's a proposed amendment to section 54 alcoholic beverages of the North Branford zoning regulations to modify the text of section 54.4.1 location to add the following sentence to the end of said sentence. In quotes, except that liquor outlets for on-premises consumption of beer and wine only shall be permitted within 500 feet of any church, synagogue, college, school, park, or town-owned playground, end quotes. Applicant Albert Pasilio.
Seated for his public hearing is regular members Leskovitz, Galdenzi, and Dulac. So, what do we got?
Good evening, Mr. Chair and members of the board. My name is Bernard Pellegrino. I'm an attorney with the Pellegrino Law Firm located in New Haven, and I represent Mr. Pasilio in regard to this application. As you just heard, the application seeks to amend Section 54 of your regulations regarding sale and service of alcoholic beverages. As you know, your regulation regulates both the sale of on-premises, the sale of alcoholic beverages for on-premises consumption and for off-premises consumption, in other words, package stores. We're seeking to amend Section 54.4.1 to add the language that would permit liquor outlets for on-premises consumption of beer and wine only within 500 feet of the church, synagogue, college, school, park, or town-owned playground. I wanted to start maybe with a little history. Your town enacted zoning regulations in 1962, and language very similar to the language that you currently have was part of the original enactment of zoning regulations. And for towns that had enacted regulations on or before that period of time, this language was very commonplace because the old Liquor Control Act contained certain regulations for the sale of and consumption of alcohol-like beverages. And this language very similar to the predecessor to our current state statutes. Subsequently, the state regulations were amended to eliminate the distance requirements. And many towns thereafter who enacted regulations didn't include the regulations, and other towns subsequently amended their regulations to change or modify the regulations in one way or another. In preparation for tonight's hearing, I did a little research, and I selected 12 towns in the vicinity of your town. And I have a handout for you that I wanted to present.
Oh, that exhibit 1.
Essentially 3 sections to this handout. The first section on page 2 is local municipalities with no regulation currently of the sale of alcoholic beverages either on or off the premises. And I provided you with, in this case, because there were no regulations that affected it, the appendix of the zoning regulations for the towns of Madison, Branford, Durham, Orange, and Shelton, which towns have no regulation for the sale with the distance requirements similar to yours. The second section, which is about midway through the packet, is those local communities that regulate the sale of alcoholic beverages only for consumption off premises. In other words, package stores. And those are East Haven, Guilford, New Haven, West Haven, Wallingford, and Hamden. Hamden does not have the restriction in their zoning regulation. They have it in the code of ordinances in the town. And the regulations vary slightly, either 500 feet like you have, some have 1,000 feet. Others have 1,500 feet, again, between package stores. So they regulate the distances either between package stores and/or between package stores and schools, parks, and churches. The only town in the vicinity of you here in North Branford that has regulations that regulate both the package stores and restaurants is North Haven. And I've enclosed their regulation. I think it's relevant to this discussion. I don't think it's binding upon you, obviously, but I think it shows that our treatment and consideration for locations that serve alcoholic beverages over the years has changed. In the 50s, there was perhaps greater concerns or stigmas attached to locations that sold alcoholic beverages. I think over the years, especially as you can see from the comparison of local communities, for restaurants, the service of beer and wine at least, and arguably other alcoholic beverages considered common. People who go out to dine would like to enjoy a glass of beer or wine with dinner, and so for a variety of different reasons, the regulations that prohibit or restrict the locations of those restaurants has become less common. To it, only one town other than you and, kind of the New Haven County area still has such a regulation. But I think there's other important reasons, some maybe even a little more relevant to zoning in your town, that I think support changing the regulation. As I mentioned, from an operational standpoint, I think restaurants, the sale of beer and wine is an important aspect to the viability of those businesses. As I said, people who go out enjoy having a glass of beer or wine with their dinner, and so in order to support that business community, I think your regulation is certainly not helpful to that community, and I'll get back to that in a minute. Secondly, I think from a regulatory standpoint, changing this regulation would be helpful. Why do I say that? Because restaurants might be prohibited from selling beer or wine because of their location vis-a-vis schools, parks, and churches. They offer their customers the opportunity to bring in their own beverages. And when they do that, I think there's a loss of control both from the state level and the local level in regard to service of the beverage, who's bringing it in. So there's less control and supervision to the distribution, people bringing it in themselves, which is permitted. So I think there's a fair argument to be made that by permitting the restaurant to serve beer and wine and then having them have to go to the state, apply, get the permit, and then supervise the service and distribution, you really do have greater control over, again, in conjunction with the state, greater control over the distribution of alcohol beverages. Our client site, which he's redeveloping, the old Amato's Pizza, I think previously afforded customers the opportunity to bring in their own beverages. I think from a zoning standpoint, which is why we're all here, there's another good reason specific to your town. It also has an economic development component to it. And in meeting with Ms. Dukes prior to this evening, we looked at your town map, the commercial B1 and B2 districts as they are distributed throughout the town, and kind of the business districts where restaurants are permitted. And what we found, and what she found, actually, she had done some of this research beforehand, was that many of the locations in those districts are knocked out under your regulation because of the fact that you have schools, churches, playgrounds, et cetera, kind of mixed into your business district. So
I'll just let you guys look at this map. This is, you probably remember this from last spring. The hashed parcels are parks or playgrounds, and the solid parcels are churches, and then the just outlined parcels are schools. So, the Jerome Harrison School for Mr. Pacilio that Attorney Pellegrino is representing, you can see is over in this corner there, where the B1 district begins in the western portion of town.
So if the sale of at least beer and wine is important to restaurants and their viability, and from an economic development standpoint, you're looking to attract businesses to your B1 zone, there's some tension because the locations most desirable from not only a business standpoint, but most permissive from a zoning standpoint, a number of the locations that would be ideal for restaurants are knocked out under this regulation, which would be solved by this amendment. Finally, I think that when you look at the primary period of sales, time of the day for beer and wine at restaurants, you're looking at time frames generally which are outside of the most common operational hours for schools, churches, parks, and playgrounds, serving those primarily. And the majority of the sales during the evening hours, the schools are closed, churches typically not having services. Same thing for parks and playgrounds, which most of which close at dusk. So the impact issue, I think, is less apparent given those hours of operation. And I guess lastly, I know these things are kind of gradual, we have to get used to it. We at least for our purposes, attempted to restrict it only to beer and wine, because that's the primary use that our clients permitted, and it's the majority of the sales, generally speaking, for restaurants. So those are the reasons to support our application. Happy to answer any questions you might have.
Yeah, this won't be a question, but I just want to give you a little background. I'm not sure if you know that we did revise this, as Carrie just mentioned, in
We did
March.
go through the history. I am somewhat familiar with it.
So when we did that, there was two applications at the time.
Yes.
And we kind of took a look at both of them and then added our, we looked holistically throughout the town when we did that. So I just want to give you some of that, some of that background on that. But one of the questions, I had back then, and I'm gonna ask the same one now, is when you talk restaurants, and I know we're talking about one particular restaurant establishment, that's the hours of operations, but if you change this for the town overall, what happens if you have a bar that serves that serves food, considered a restaurant in that area? Now it becomes more of a bar than a restaurant. Now, I understand this individual is, when we're talking about this one establishment, it's not gonna be like that. But when you make a change throughout the town or to the regulation globally, there's those things can happen.
Those things.
So it's hard to regulate the difference between a restaurant, and a bar that serves food, and then they're interchangeable. I mean, you can call it a restaurant, you can call it a bar, but that's some of the things we did look at back in the spring when we put that together. So.
And we were aware of it.
This is just beer and wine.
Yeah, that was gonna be my answer.
Because then I wondered if that's fair to the other places, almost the opposite of what you're
Yeah.
saying.
Well, I'm just, yeah.
Yeah, no,
I'm just
I know.
wondering, that's
Yeah,
one of
I'm
the
just
things in there.
we-
You've limited it. I
thinking
get
out
that.
loud.
We
It's
were
limited
aware
the
of that,
scope.
and I think by limiting it to beer and wine, I've been in a few bars before. I've never been in one, quite frankly, that only served beer and wine. But I've been in a number of restaurants that have, and I think limiting the exception to the rule to beer and wine, I think, eliminates that fear. Because, as I said, I'm not really aware of a beer and wine bar only. I think there's also certain regulatory differences at a state level for the type of permit you can get. But primarily, the beer and wine limitation, I think, eliminates, I hope, that fear. Certainly, it limits it.
The only thing that comes to mind is, and I don't know if this is necessarily true, but what about some like private clubs? Maybe they would just serve like beer and wine. I don't know, like an Elks Club.
Yeah, the one in Center
Yeah, I don't know.
Northford.
Some, but
One in Center Northford.
probably most likely not. It probably is
First of
more
all,
the
No,
And most of those clubs have
full bar.
liquor bar licenses.
Right. So
Well, they
we
don't-
have the liquor
And,
as opposed to.
I mean, we owned a very exclusive restaurant over the years. And what happens is some people do come in just to the bar, but not that many. But in other places, they'll come in mostly for the bar. Most of our customers had their liquor with dinner, or after dinner, they go sit in the bar for a drink. But I agree with Attorney Pellegrino that, and I brought this up at the regional meeting, which I told you, and most of the other towns were in agreement that the regulation is really archaic. We have liquor laws that prevent people from over drinking, that the restaurant is liable if a patron, not patient, because, goes out and hurts somebody because they were drunk. Kids don't walk to church or walk to school like they did in the 50s. So, and to promote business or encourage business, then personally, I think the regulation should be abolished. And we should allow restaurants, all restaurants, to have, I mean, if you want to just limit it to beer and wine, I think it's foolish, because somebody's going to come in eventually and say, well, gee whiz, why can't I sell a drink? Maybe there's a way around it. Maybe you can say, when the restaurant stops serving, the bar has to close, or something like that, that will prevent it from just being people coming in, afterwards just to drink. But even if you just serve beer and wine, people could still come into the bar, not go in for dinner or pizza or whatever, and still get drunk. So you're not accomplishing anything. And it was the consensus of most of the other towns that they were looking at doing away with their regulation on justice, not on off-premises. That still stands as the way we already had it. But we've already passed a regulation that just because I have a restaurant can serve liquor, and you're 3 doors down, you can't. We already got rid of that one, because that made no sense. And in my opinion, this doesn't make any sense.
So, right, just to go over what our current regulations say, it says that no liquor outlet, which is defined as a location where any alcohol, wine, beer, and/or ale is sold at retail for consumption on or off premises. But it says that, let's see, no liquor outlet shall be located within 500 feet of any church, school, synagogue, college, school, park, or town-owned playground, except when a state highway separates the liquor outlet from any church, synagogue, college, school, park, or town-owned playground. Then the required separating distance shall be reduced to 400 feet.
That's for liquor stores, off premises, not for on premises.
On and
Current.
On and off.
off. That's our current
That's on and
regulation.
off.
On and off.
Okay, didn't we
Our current
reduce
is
the,
We deleted the section that had the
1,500 feet.
oh, right,
rule
per
between
right, okay, that was the part that
Right.
we eliminated. Well, anyhow, I still feel the same way. It should apply to liquor stores and not to restaurants. And then, they have to go through and get a liquor permit. They also, I'm not really sure whether the permit is different from the state, whether you just serve beer and wine or liquor, beer and wine. I'm not really sure if there's a different permit for that.
Yes, there is.
That's Mr. Basilio saying yes.
Bill, you have anything?
I mean, I think it's pretty compelling when you see that our neighbors really don't have any regulation of serving on-site beer and wine. And another compelling thing for me was the regional COG, right?
Yeah,
That you brought information back that basically said, most of the members there don't feel the regulations needed, so.
they've already
I
gotten rid
think
of it.
that, yeah,
or
that was,
they're in the
was kind of
process.
eye-opening for me a little bit. I never really gave it much thought,
Well,
but.
I mean, the information he provided was some of the information we had back in March as well. And I don't remember the whole context of the discussion, I'm just gonna put it out there, because from what I remember, there was an individual that,
That was for.
That was for
asking-
on-site, that was on,
no, he
off-site.
was talking about specifically the other towns. I can't remember which side he was kind of portraying, but he did bring up, he did his homework and brought up some of the towns that don't have the regulations as well.
But he was talking about off premises.
No, he was talking.
Yeah, but he was talking about
He was
off
just telling us
premises.
what he was just telling us
The
what we were.
situation
Right.
was off-site, though, even though it was a generalized
Right,
change. The reality was we were dealing
Well,
with
Right.
a
I mean, again, we
couple
reduced,
situations.
it was on-site as well, because we reduced one of the, we looked at it globally after we got both of those regulations, or applications, and made changes overall, so even the on-premise, we reduced that, or waived it completely, right, the 14, or,
15.
yeah, so we looked at it both on and off when we did that.
yeah, but I don't think we were looking at the whole picture. And I think that this brings a lot more to light, and there's no reason that you shouldn't, even if you just made the the regulation a month ago, doesn't mean that something else been brought to light that should change it.
Oh, I agree. I'm just saying some of the stuff we discussed back in March, and I don't remember all the particulars, maybe because of, we wanted to keep those areas around the school and the churches or whatever, and, have economic development, but have those areas that were there, keep them.
Off premises.
Right
That's
or-
what we,
right- right or-
regardless how we
Yeah.
changed it, it
It was
really
on and
was off premise.
Yeah, right or wrong, the only thing I recall, the whole focus in my mind, from what I recall, was the off-site.
It was.
It was really, that was the main impact. I know we said that this would help restaurants more because,
Well, it would help them
a little bit, but
only because
The
we
distance.
reduced the distance, that you could have liquor next door to me in a mall if you had a restaurant.
And I'm not voting right now, I'm just saying that,
Oh, no, I got
I'm
you.
just
I got
finding
you,
this
yeah.
fairly compelling to me, because I'm like, okay, wow, I didn't realize that. I mean, it seems like most surrounding towns have either abandoned it, never had it, or, changed. And if the regional cog kind of
The thing
supports
is
that.
that you have to look at it at really, what does it affect anymore? Some of our zoning regulations are archaic
Right.
because the town has grown, the population is different. As they say, you have school buses that drop kids off, people don't walk to church. Everything is by car, by bus. So, that whole scenario makes no sense. What difference does it make if it's next to a church or not next to a church if there's a restaurant? If you choose to go to a restaurant after you went to church, well, so be it. It's up to the restaurant to say, I'm going to be closed on Sabbath day, or, I'm certainly going to uphold the liquor regulations that, you're not going to leave here or not going to get drunk.
Do we have any
Yes, so I did send this proposed text amendment to the Regional Council of Governments. They said, by resolution, the RPC, which is the Regional Planning Commission, has determined that the proposed zoning regulation amendment does not appear to cause any negative intermunicipal impacts to the towns in the South Central region, nor do there appear to be any impacts to the habitat or ecosystem of the Long Island Sound. And that was from James Gouletti, the vice chairman. And so that was the only
Okay.
referral.
Is there anything else you want, or I'll open up to the public for? Would anybody like to speak on behalf, or on regarding this application?
Don Delvecchio, Sterico Incorporated, Norford Center. And then first off, I know you guys know this, I'm sure Carrie informed you, you don't need to hear this application this evening by statute. It was proposed within 1 year of the last ruling, or the last decision you made, so you're not obligated to hear this if you choose not to hear it. The other matter that came up is, in the adjoining towns, it's very deceiving when you point out that other towns don't have these regulations, separating distances for restaurants from schools and churches. And the reason for that is a lot of the other towns, they're permitted use zones for alcohol, whether it be restaurants or package stores, are nowhere near in proximity to their schools and churches. So there was no need for them to have separating distances because they control it through their zoning, through their permitted use zone. So alcohol, restaurants, package stores could not be in close proximity to your churches and schools because they're controlling that through their zoning regulations. That's not what occurred here in North Branford. What happened here, your business districts grew around your churches and schools, and that's why there was a need for separating distances. And that's why you currently have them. This issue came up and it was discussed at length at the last hearing. That's a very important distinction between the town of North Branford, Durham, Madison. They're controlling the use of alcohol in restaurants, whether it be on-site, off-site, through their zoning regulations and their permitted use zones and their B1 zones, which are nowhere near in proximity to the schools and churches. That's very important. And the other thing, Fran, is I love you to death. You know that. I want to say that on the record because I do care for you deeply. And I sometimes disagree with you. And one of the things I disagree with you on is, this whole thought that, on-site consumption, we're not really concerned about. It's that it's the off-site consumption that we're concerned about, which I can't understand that because the off-site is the least offensive of your uses. It's a retail outlet. People go in, they purchase liquor, and they go home. The others, on-site consumption, it's not just restaurants, and I know that primarily you guys are focused on restaurants, but it's also pubs, taverns, bars. affects all those.
Social clubs, too.
Social
Yeah.
clubs, VFW, it affect, that's all on-site consumption. And like, like you say, I still disagree with this whole concept about off-site, on-site consumption. To me, the on-site consumption is the most offensive use. The off-site is strictly a retail use. People come in, they're there for less than 5 minutes, they purchase their alcohol, they leave. But you have to understand that, and I know this was brought up, it could be, once you open up Pandora's box, it's not just for the pizza parlor, it's for the Hooters, the Tilted Kilt, you could go on and on. You're essentially, once you open that door, in close proximity to your schools and churches, you no longer can regulate it because you can't do what other towns are doing and regulate it through your zoning regulations and your permitted use zones. That's how they're regulating it. You need this regulation, this separating distance, to protect your schools and churches. Unless, and quite honestly, if you don't believe it's necessary for on-site consumption, I think you should eliminate it also for off-site consumption. And for your package stores or your convenience stores or whatever else there may be for off-site consumption as well. And just listening, at the last time we went through this, we did to promote economic development, and I think that was a great idea, eliminating the 1,500-foot rule for on-site consumption. I still agree with that. I think it was a great idea. And you pointed this out. I think it's more critical to protect your schools and churches and the young children and adults that could be influenced from the detrimental effect of alcohol sales, advertising, and so forth. But the 1,500-foot, once you protected your schools and churches, the elimination of the 1,500-foot rule for on-site consumption was a great idea. It promotes economic development. If one restaurant has it 3 doors down from another, it does permit them to also serve alcohol. I agree with that wholeheartedly. Through the presentation tonight, I'm assuming there is no restriction at all. The way this amendment is worded, it could be within 25 feet of the school or 25 feet of a church. Is that right? Is there any separating distance proposed? None whatsoever, correct? For beer and wine only. All right. And so that presents a concern on my part. Just going through some of my quick notes here that I took down. I think that's it. I mean, like you say, we've gone through this before at length, and I know we had many discussions during the spring on this, or number of people. And the reason, the original proposal that came before you was to do exactly this, to eliminate the separating distance between schools and churches for on-site consumption, whether it be restaurants, pubs, taverns, and you guys rejected that. And no one was really in favor of that. The full board was not in favor of that. You requested amendments to ensure that separating distances was reincorporated back into the regulation. So this is essentially the same proposal that you heard in the spring, and then it was rejected, and you told the applicant to come back and to ensure that there was a separating distance because you were very concerned about the detrimental effect on the school, the churches, the parks. And as a matter of fact, what you did is you actually strengthened the regulation because it used to be more lenient where the measurement was taken from the building itself, whether it be the school or the church, and used to measure from the nearest corner of the church or school to the nearest corner of the liquor premise. Then you strengthened it, and you took it from the closest corner of the property boundary, which really...
Just to clarify, sorry.
Yeah.
That's correct, but just for schools. And that
Just
was-
for schools,
yeah,
just
not
for
churches.
schools, right.
And that's
Just,
because of the
no, I understand,
playground
just for schools though,
structure.
you did strengthen it, and you said, you know what, we don't, we're gonna measure from the property boundary, not from the school itself. So the school could be set back 600 feet off the road, and I don't know if this affects their application or not, but I tend to agree that it should be measured from the school, but depending upon the layout. You guys changed it the last time from the nearest property boundary and not from the school, but I think you should reevaluate that at some point, that should the measurement be taken from the actual premise? And I think it should, because that's what you're really concerned about. And I know this issue came up, and Kerry raised this. I think it was a concern about the playgrounds at the schools, and that's the reason why I believe it was strengthened and the measurement was taken from the property line, not from the building premises, because some of the schools have playgrounds, and that became an issue. And I think that's the reason that you guys selected to do that. But once again, I think you should go back to the primary use of the building. Does one playground apparatus constitute a part? I don't know. And, so there are a number of issues. Believe me, we went through this many, many times. Many applications were submitted, many revisions. And like I say, I still disagree with this whole concept. Oh, my God, on-site consumption, no one seems to be concerned about, but off-site consumption, that's strictly a retail outlet where people come in, purchase one beer, and go home and drive away in their car. They may go home and drink that beer at their home. That, to people, is alarming. Why this on-site consumption is not, I don't know.
think there was more to it. I think it was, your arguments are certainly valid, but I believe that we discussed the businesses that are already established, that we were concerned, this is a small town, and we certainly don't want to make a regulation that's going to put a business that has been established for years and years out of business to make a new one come in. And you can give the argument that that's economic development, but is it really? And you can give the argument that it's competitiveness. Yeah, sure, it's competitiveness, but you are going to drive somebody out of business, because one store could be big enough and have enough money behind them to maybe take a loss or a very small margin. I don't think they can take a loss according to the state laws, but they could take a penny margin on it and still drive the other company. So it wasn't so much that because it's more offensive to have a liquor store within so many feet of the school. It was more that we didn't want to allow new liquor stores come in. And plus, this town already has as many liquor stores as the state will permit in one area. This is a small town. We want to promote business. We want to encourage business. We haven't had an influx of people come in and say, hey, I want to open a liquor store, but there's one down the street. So, if that was the case, maybe we'd have to look at the whole thing. But right now, there's nobody that comes in and looking to open a liquor store that's in competitiveness with another business. And I think that was more the crux of the reason that we kept the on the off-site. Not so much that, yes, they can get drunk in a restaurant, and they certainly don't get drunk in the liquor store. I think it was more what I've just stated.
Yeah, and I think the point you're missing, though, Fran, is that the off-site consumption, when you think of a package store, you're thinking of a traditional package store, but there are other uses for on-site consumption. For instance, we have the cigar and tobacco store there, and now that was recently approved. The legislators recently approved this last session, where you can combine your cigar tobacco sales, and this was just approved the last legislative session, and incorporate and sell alcohol on premise. So it would be a different use. It wouldn't be your traditional package store. It would be a different use.
But that doesn't mean that it would be passed in this town, and this town is the
No.
only town we're considering.
Right. No, I understand that, but I just wanted to point that out. There are different uses. It wouldn't be a traditional package store
Yeah, and
located
as
directly.
far as people, a bar is a bar. You mentioned Hooters and stuff.
But, yeah.
I mean, again, this town is not going to approve such an establishment to really come in.
But
as
what
a
would you
bar.
deny it on, though? Aesthetics?
No.
We don't,
Yeah,
we want,
So-
let's, at this
Because
point,
see, you're very limited.
Okay. Instead of,
Right,
I mean, I don't
right.
wanna hash out the
Okay.
difference between package stores.
Right,
and-
right.
I mean, the application was what's
Okay.
in front
I'm
of us
done.
now.
I'm
No, I mean, thank you very much.
All right.
I mean,
I
that's what we're talking about. I mean, and some of the points he was bringing up, I think we just have to, like, the map here, we're saying we didn't take in consideration, the businesses and the zoning. That's what we took in a lot of consideration. That's why we have this map from back in the spring, is because we reviewed different things like that too. So,
I may have to
yeah.
go through this again, because I'm just trying to, it doesn't
think-
seem like we have a lot of convergence of
I think we just need to
B zones with
I can-
churches
I
and
can
schools
have a
anyway, right? There's probably
Clearer
very.
version
Yeah.
made
No,
up.
I don't mean that. I meant, you may have to just point out the areas
Well, and
again for me.
if I printed it in color, I think that would
Yeah,
help,
okay.
because the black and white is just difficult to see what's B1, what's.
Because my sense is we don't have that many business zoned areas that are going to be, there's probably just a very limited few, right, that are near a church or school.
So the ones that come to mind.
Northford
if
Center,
going- Right, Northford Center.
Pacilios.
Right, Northford Center, Pacilios, North Branford Center, so 22, thinking about 22 and 80, there are a few churches there.
Right, okay,
And that's pretty much, those are the main
But we
ones.
also
And
discussed the
then
fact
with
that,
Harrison.
you know, on Route 22, you may not think of it as a church, but it is a church. I don't know, Assembly of God or something like that.
Yes.
It's still a church, so the same rule would apply. And, you know, anybody could open up a church, any place.
Storefront churches. right?
Yeah, I mean, they're common, and maybe not here in Northford, but they are common. So, you know,
The other thing, just to point out that Mr. Delvecchio raised is, and I can look at before the next meeting, is these other towns and how they regulate the alcohol in their regulations. I think that's a good point.
Yeah.
And,
Yeah, it was a good point.
One thing that we have in our regulations is we do define restaurants, but it doesn't speak to alcohol or not. It just, and it's honestly the only definition that we have is restaurant, indoor. And it just really speaks to,
is there regulation under bars?
I think that would help for me to
no,
look at
there's
the.
no definition of bars, but for every restaurant, and every restaurant requires a special use permit, but only if there's a change of use. Does that make sense? So
Yeah.
if there's an existing, so I was trying to think of an example, if there's an existing restaurant that maybe only serves breakfast food, say, but then they change to Buffalo Wild Wings, and, you know, turn into more of a sports bar, so then they would be open at a different time, serve alcohol possibly. Unless they did major changes to the building, they wouldn't trigger a site plan review. Most likely they would though, and then they would need to come before planning and zoning for a special use permit. So
Yeah.
I mean,
for those,
when-
there should be a special use permit, which would require them to come before you, so you'd have some latitude, but you couldn't say you can't serve alcohol
If this
if
changed.
this went into place.
I mean, when I mentioned Hooters, it was really more for a bar. I'm thinking of a
Right.
bar, not of a restaurant. But if-
That's an interesting point, though.
Yeah.
That was an interesting point Mr. Delvecchio mentioned about if they are zoned differently.
They're regulated
They're
in their
regulated differently,
text.
yeah.
Right.
Do you yeah, go ahead.
I don't know if the public's done, are you still in public?
Oh, you can
My,
comment.
I know Mr. Delvecchio is very familiar with the history, and I, as you, don't want to really talk about bars and the differences between restaurants, but I do have to take exception to the statement that the other towns don't need the distance requirements because they regulate service of alcohol on-site by zoning. It's just not the case. Let's think. Think of the town of Branford. The major park in the town is the Green, with 3 churches or 2 churches around it.
Yeah.
You could hit a 9-iron to 9 different restaurants surrounding the Green. The same is true in Guilford. The same is true in the Central District of Madison. I go to St. Rita's Church in Hamden. There's the
Yeah.
Park Central Tavern, the Paulinetti's, which are right next door. My office is in New Haven. Right down the street is a very nice restaurant called Lorchio, full-service bar right next to St. Stan's Church. So it's not true that other towns regulate around parks and schools to eliminate bars and restaurants. They are in close proximity to many, many in every single town in this booklet. So that's just not true. And I know as you think of many of the towns, you'll come to the same conclusion. Those restaurants exist right on the Green, right next to churches.
Yep.
And they have neither zoning restrictions, because those areas that I just mentioned to you are all zoned general commercial business in those towns. They don't have separation requirements, because that's where the people in town like to be. They want to go out to dinner, and they want to have a drink. And so, again, that's, I think, good planning, good economic development, and I think you should do the same.
I just want to say one more thing. I don't think we should be worried what the other towns do. The other towns have different scenarios, different populations, different business areas. Our town is unique of the way it's been spread out through the years. So we should be looking at what is right for us. And that's really it.
Anybody else would like to speak on the public?
I just want to point, not that I'm disputing what Bernie has said, but you have to understand that, as I stated earlier, a lot of these towns, their regulations weren't enacted till 1962, some later. And so a lot of these instances that we're referring to in Guilford and some of these local towns are pre-existing non-conforming uses that they can't change. But they do currently, once the regulations were enacted, they regulate through their zoning, their permitted use zones, where these establishments are permitted, whether it be alcohol on-site, off-site. So a lot of these restaurants, I'm very familiar with the center of Guilford, are pre-existing non-conforming uses near churches. And I know some of these other towns currently don't regulate, off-site, on-site consumption. That is true. But a lot of the towns do regulate it through their zoning regs and their permitted use zones and so forth.
Yeah,
But-
we'll review that, Carrie.
Yeah,
Look at it.
I think so,
We have
too.
this whole packet, so
Right.
so we can pull through.
Yep.
Thank you very much.
Yep.
Is there anybody else like to speak on this? Any other comments? I think because of the information was provided tonight, that we can look through it, so I think we'll leave the public hearing open and continue it to our
You can,
next meeting.
October
right,
15th.
you'll vote on it though, later on in the agenda.
What's that? No, we're gonna continue we'll leave the public hearing open.
Right, okay.
Yep. All right, so this public hearing will be continued to, what was it again, October
October 15th.
15th. Thank you very much. Thanks. So I don't want to read this book. Billy, you didn't read this whole thing.
Yeah, I know.
I know. And I already looked at them once before, back in March. Gonna do it all over again. Okie dokie. All right, the next public hearing is PZ application 2015-11.
Okay, again, the legal ad was posted in the Sound on Thursday, September 17th, 2015, and Thursday, September 24th, 2015. Legal notice, Branford Planning and Zoning Commission. Notice is hereby given that the North Branford Planning and Zoning Commission will hold a public hearing at 7 p.m. on Thursday, October 1st, 2015, at the North Branford Town Hall Council Chambers, 909 Foxton Road, North Branford, Connecticut, to consider the following. This is C, PZ application 2015-11, proposed amendment to the North Branford zoning regulations to add new section 38, age restricted housing district, applicant Diane Whitney, Pullman and Comley, LLC.
Seated for this public hearing is members Leskovitz, Galdenzi, and Dulac. Just before we get started, for anybody who, we do have additional copies of what the proposed amendment or regulation change would be, if anybody would like a copy of it. Just to give you a little quick background of how this public hearing will work. Our applicant is gonna walk us through what the changes or the amendment that they're proposing. We'll have a chance for some comments from the commission if necessary. We'll also, after that time, we'll open it to the public for any comments, and then we'll determine throughout the process if this would be a continuation or something could be acted on tonight. We also have some we'll have some reviews from in town as well. So with that, you can begin.
Thank you.
Thank you.
Good evening. I'm Diane Whitney from Pullman and Comley. And as you know, this is requesting the adoption of a new segment in your zoning regulations to allow called an age-restricted housing district, to allow housing for those age 55 and older, in order to give additional housing opportunities for those people and to preserve open space in North Branford. Very quickly, some of the most important segments of this are that the site must be 5 acres, at least 5 acres. 20% of the site must be preserved in open space, or if the open space is provided at a different site, it must be 30% as big as the site itself. It calls for a maximum density of 6 units per acre. The procedure that would be followed, if you pass this regulation and it becomes part of your zoning regulations, the procedure that would be followed then would be that a zone change application would be filed to locate this zone someplace in town, because this is what's called a floating zone, and until you get an application to actually place it on the land, it is not located at any particular spot in North Branford. If in fact you pass the zone change application to locate the district someplace in town, someone would then have to go through a special use application and a site plan application. Public hearings would be required at both stages of that. So you would have multiple public hearings in order to actually approve something to be constructed. Section 38.5 of the proposed regulation has details of the application. 38.6 has the development standards that would be required, which includes that streets must be constructed to your normal town standards. And section 38.8 requires a financial guarantee for site improvement work. This procedure allows you to maintain maximum control, really, over what happens. You already have, I'm going kind of fast because I know you've heard this before, so stop me if you have questions.
Oh, no, you could take, we want to make sure the public is well informed as well. I mean, we had an opportunity, but whether
they
they
haven't.
were here or watching, we would like to, so take us through the whole project.
Okay.
Or, I mean, the whole proposed amendment.
You already have a floating zone in North Branford. It is your specialized economic district, which is a floating zone. Floating zones have been around in Connecticut for some time, and they are being used pretty extensively right now. We recently, in fact, got a floating zone passed in Cromwell that is for a multi-district, multi-family housing. There are 2 cases that I'd like to give you that establish the authority in Connecticut for floating zones. One is Lurie versus Planning and Zoning Commission of Westport, and the other is Sheridan versus Planning and Zoning Commission of Stamford. In addition to giving planning and zoning commissions the authority to actually pass floating zones such as we're proposing, these cases also state that when you pass a floating zone regulation, it is not appealable because there is no one that has standing to appeal it. In order to appeal one of your decisions, somebody has to prove standing. And most often, they prove standing to bring an appeal by saying that they own property within a certain district of the property to be rezoned. In this case, of course, it applies to no property. So when you actually pass a change in your regulations to put a floating zone into place, there is no way to appeal that. There is, going forward, a way to appeal your subsequent decisions. When an applicant, after you've passed the floating zone regulation, when an applicant then comes in and says, I'd like to locate this floating zone on this property on Main Street, that is an appealable decision because there would be people located within the required distance of that. And also for the special use application, that would be an appealable decision. So the procedure really allows for a great deal of control on your part over the whole process. And it also allows for meaningful participation by the public when you're actually getting to the point where somebody wants to develop some of this property. You have a letter from the Regional Planning Council that asks that you, or suggests that you look into this application a little more because it might have inter-town effects. And I would suggest to you that actually passing this regulation does not have such an effect because it doesn't apply to any land. But it might have an effect when somebody comes in to actually locate a zone somewhere and to develop it. At that point, I'm not sure how your procedures go, but I would think at that point, if the property is within 500 feet of a surrounding town, there would be a notice to that other town and maybe to the Regional Planning Commission also, because at that point, it might have an effect on a surrounding town. But at this point, just passing the regulation does not really have an effect on another town. When we have discussed this matter in the past, there was some concern about how would the age restriction be enforced. And I actually have a couple of ideas if you want to strengthen that enforcement mechanism for the age restriction. I have too much paperwork here. I actually have two suggestions if this is something you want to consider. One comes from the town of Farmington, and it's fairly detailed, and says each dwelling must be occupied by persons who are 55 years of age or older, the spouse of an occupant who's 55 years or older, an occupant pursuant to, let me give it to you and then it's easier to describe it.
Mr. Vandenberg, you're all set. I mean, you're welcome to stay, but
Oh, it's on.
we completed it, yeah.
Okay.
Yeah, you're all set.
Thank you very much.
Thank you.
So if you wish to strengthen the age restriction, this longer one, which says new section 38.3 age restrictions, this comes from Farmington. And it is, as you can see, a much more detailed way to enforce the regulation, although it also has some sort of flexibility and speaks to what happens if the person 55 years or older dies and the spouse is not 55 years old, what happens in that circumstance. And it also makes an accommodation for a personal care attendant who might be living in the home too. And it allows a child 21 years of age or older who may reside with his or her parents. And finally, it requires that the development and dwelling units shall have in its deed and leases declarations containing their age restriction. That's similar to a restriction that you already have in your regulations. The second one that I've given you, which is considerably smaller, I believe comes from Branford. And it simply requires that the development and dwelling units shall have in their deeds and leases the declarations containing the age restriction. I've looked at a number of towns that have different restrictions. And some of them are Avon, which says children 21 years old or older may live with their parents. Clinton, which says an adult child may live there only if they're essential to the care of the elderly parent. Or, but Clinton also says all permanent residents must be over the age of 21. In my thinking, those get a little more complicated than you may wish to go into. And I don't know that you need more enforcement, but I remember that we had discussed the possibility of how do you enforce the age restriction earlier. So I wanted to give you some alternatives that we could always add to this regulation, if you think that's necessary. I haven't discussed all the details of the regulation. Would you like me to do that?
Oh, please,
Okay.
please.
But how do you enforce that? I mean, it's in paper, but how is it in practical enforced? I understand the deed for a property transfer, there'd be a deed.
Right.
But how is a town gonna enforce if there's someone in there that's 45 years old? There's no way to enforce that.
You know, chances are, unless somebody
impossible.
drops a dime on them, you never know.
It's impossible. So
I've talked
that's
to,
the struggle I always have with this. It sounds good, but it's not enforceable.
You know, a whole
It's
lot
just
of
not
towns
enforceable.
have them, and I've talked to a whole lot of the planners in those towns, and they agree with you, but they also say they've never had any problem with it.
Mhm.
They don't know that it's been abused. I know that's kind of cold comfort, but that's the answer I keep getting from a number of different towns. To go into the regulation a little more, the purpose, of course, is to allow housing for age-restricted housing and to allow flexibility of design techniques on land and to preserve open space. The site must be 5 acres, and it must have the open space requirement that I discussed before. Maximum residential density shall be 6 units per acre. Then there's the age restriction. The application, we went over before, actually. The application to actually place the zone requires a statement about the development and also requires a conceptual plan, which is something less than the detail you require in a site plan. But it's similar to a site plan in that it shows you how the road pattern would be and a general idea of the design of the housing units. And then you go on to the special use and site development plan procedures. Those are really taken from your current regulations, so that the site plan requirements and the special use requirements are the same as currently in your regulations. So there's no dilution of your standards going forward. The development standards are minimum standards, and they include the lot must have 125 feet of frontage on a public street. Each building must have a front setback from the street of 40 feet and a rear setback of 30 feet. So if there are single-family homes, the separation between them must be 20 feet. The separation between duplex or multifamily buildings must be 30 feet. The open space requirement, and the open space, if you decide you'd rather have a fee in lieu of open space, this permits that. Building height is 3 stories. Building coverage for the lot is 35%. Impervious surface area ratio is 50%. 1.5 parking spaces shall be provided for every unit, plus spaces for guests in a number that you will determine based on the plan. Spaces in garages and driveways count as required parking spaces. There shall be a buffer area 15 feet wide containing landscaping, fencing, and/or berms between this district as a whole and adjacent property in order to provide privacy from the adjacent use. That dimension can be reduced or can be combined with a required rear setback if you believe that the provisions included in the plan are sufficient to provide privacy. And as I said before, streets shall be to town standards. In order to approve a development like this, there are a number of findings that are required. They're basically the same as you require for any subdivision, that all the utility services be adequate to serve the new development, that the streets and drives are adequate, that there is a provision for continued maintenance of the development, including open space or recreational areas, and the financial guarantee. There is a financial guarantee for infrastructure construction. Let's see. Construction must be completed within 5 years from the effective date of the district, except you may extend that by 1 year if necessary. What's in here now for enforcing the age restriction is that you may require affidavits or proof of age, and that if the dwelling units are rented units, an affidavit from the owner indicating the methods he or she has used to assure compliance must be provided. Then the requirements for modification of the plans are basically that if it's a large modification, you really start the process over and go through a public hearing. If it's a small modification, you can simply treat it as a modification to an already approved site plan. So those are the details of the regulation itself.
So the 30% non-contiguous, is that entirely non-contiguous, or can it be a combination of
Oh,
contiguous and non-contiguous?
we didn't think of that. We only thought of it as either it's on the site
Yeah.
or it's not on the site. I would think that you probably would have the flexibility to determine that yourselves, because the applicant has to prove that, particularly if it's off the site, that in fact it's property that the town values as open space.
Yeah.
So I would think you have some flexibility there.
How do you come up with 1.5?
Parking spaces?
Yeah,
Because I looked at a whole lot of other towns, and that seems to
I
be.
mean, it makes no sense with a half a parking space.
It certainly doesn't per unit. Overall, it seems to even out.
Well, according to this, actually the garage and the driveway constitutes 2 spaces. So the
True.
1.5 just doesn't make sense to me. I do have a question for Carrie. I didn't realize we had a floating zone. What economic district is in this floating zone?
Well, as Attorney Whitney said, so for a floating zone, it can be applied anywhere.
I understand
town.
that, yeah, but
So,
what's the one
I'll
we
just-
have?
So I'll read you the. It was a specialized economic development district.
Mhm.
Let me just read the. So it's a class of district which delineates a planning area for desirable economic development activities in a park-like setting.
So,
So it
Does
was
it apply-
effective in 1995.
I was gonna say it sounded vaguely familiar, but we don't have anything that it was ever applied to, do we?
Correct, right. So it says, the Specialized Economic Development District is established to provide an aesthetically attractive working environment exclusively for and conducive to the development and protection of offices, research and development institutions, a variety of manufacturing establishments. The district is to promote
Sounds nice.
development that is practical, feasible, and economical, and an asset to the owner, neighbors, and the community. And then it lists the purposes of the district. So that's section 36 of our zoning regulations. And, it specifies the size of the site and the lot area.
It gives a minimum and maximum?
It gives a minimum of 800,000 square feet.
So,
The minimum permitted individual lot area within the SED is 80,000 square feet.
So that's 2 acres.
Right. And floodplain and wetland watercourse areas may be included in the calculations of the site.
So, if I owned 6.5 acres, and
Oh, are you-
1.5 acres was desirable to the town for open space, so that left me with 5 acres, I could put 30 units on my.
well, that's where I was gonna go.
I could put 30 units
Right.
on my.
So here.
Well, so one of the questions I was gonna have is, oh, go ahead.
I'll just pass this out.
Yeah, I think-
I don't know if I have enough copies, I'm
I
sorry,
see
but
this.
I
Or-
think, so here's a chart, and I can make copies for the next meeting. So the first chart, I looked at the number of acres, contiguous open space required, which was a minimum of 1 acre, I believe, or 20%.
If it's a 5-acre site, yep.
And then non-contiguous open space, if allowed. And then proposed units allowed, if you look at 6 units per acre, and then I did 5 and 4, just as comparison. So that's the first sheet, so just so you can see,
Yeah,
and
see.
there's no, limit on the number of acres that this could apply to. So if you had a 20, 30, 60 acre site, different things, could come into play, and we can look at the regulations maybe a little bit more as far as if wetlands can count, or if the town zoning regulations would apply. So if 50% of the site were wetlands, can you count the wetlands towards the
Developable area.
developable land?
Also, like,
To
more than
account-
25% slope is not really beneficial to an
Right.
open space.
Right.
I don't know, something like that.
Is,
Yeah,
Right, so it's not
this,
just a bunch of
this,
garbage.
proposal for this particular zoning, floating zone, only applies to, 55 and upward development, is that?
Yes, the
But
one
it-
we're proposing.
But it can be, because it's a floating zone, it can be applied wherever. You know what I'm saying? It could be with,
I
yeah,
know that,
yeah,
I know,
yeah, okay.
but it's only applies if you wanna
Right.
put in.
Yes,
My-
but
my
just to
question-
finish that thought real quick, it can only be applied to, and correct me if I'm wrong, Attorney Whitney, residential, so R40 zone land, R80 zone land, and I believe industrial, and I forget if it's I2 or I3. So there are limits to where it can be, so
Zone-
it couldn't be applied to a business zone.
Yeah.
It says zoned for either residential or industrial use.
Okay.
Personally, when I first saw this regulation, I didn't realize we had the other one for economic district, which doesn't really apply right now. To me, this is spot zoning, and it's just under a different name for a different person that wants to apply it to a particular piece of property. My concern is, there's a lot of 6-acre properties that people, they really can't develop with houses, or it doesn't make sense for them to do it. What's to prevent them now to come in and say, oh, I wanna put an adult little community in here? And I agree, we need them, but if we're looking to house the residents of this town, most of your senior residents don't live in $400,000 or $500,000 house on the average. The average sale of a house in North Branford is between $250,000 to $350,000. So would they sell their house to go into a 55 and over that is going to cost at least $350,000, if not more? Secondly, is that what happens to this development if they don't sell these units? And then they walk away from it, or they come back and say, well, let's turn it into apartments, or let's turn it into, because I have a economic disadvantage now that I can't sell them, so I'm gonna plead hardship and want a zoning change, or I wanna change the site plan. And, these are my concerns about this, is that it's too small an area in a, this doesn't happen to be in a real residential spot. This particular spot that they're applying for, it may fit all right, because it's really, it's kind of isolated. It's behind the, buildings that are business. But again, you gotta look at an overall picture of whether a 6 acre or a 5 acre lot, because that's the smallest you can build. And there's lots of 5 acres around. My own land, I could knock down my house and say, hey, I want to put up housing, for seniors now. So I'm kind of, I would rather see them come in and ask for a variance on the zoning change than to ask for a floating zone. That's only my opinion.
Can I
Oh,
unpack
yeah,
that a
absolutely.
little bit?
Yeah, that's the
One of the
discussion.
reasons I gave you those two cases is they explained that this does not constitute spot zoning, because spot
I
zoning.
know that. I know the spot zoning, you would have to come in with your particular property and say, I want to change that into a regulation that'll fit my 55 nowhere. I know what spot zoning is.
Well, but there's another concept there too, which is that spot zoning generally is not consistent with the comprehensive plan of development in the town. This would have to be, you would have to find that it is consistent with the comprehensive plan. And that's really the difference that makes it not spot zoning. As far as whether or not they sell, this provides that it could be leased, or the units could be leased, or they could be sold. And right now, this is the development that is selling the most in Connecticut, and is predicted to continue to sell the most in Connecticut as the population ages. And I'm sure, as you know, your population is in fact statistically a little bit older than all the surrounding towns, so it seems like an appropriate place where people would want this kind of housing. As far as the size of the lot, I'm interested that you seem to be complaining that the 5 acre site is too small. I was expecting the other argument from you.
Oh, I didn't get my chance yet.
Oh, okay.
So we'll save that for later. We'll just go on this one.
My
And-
argument is the 3 stories. I think 3 stories is too big. I mean,
You could
I
have.
don't know how they do these 3 stories, whether it's 1 unit is 3 stories, or it's 2 units within 3 stories.
But you could have a 3-story house.
A 3-story house.
I have a 3-story house.
Well, again, is that a unit is gonna be 3 stories, or is that 3 units in 3 stories?
You know, the way this is written, it could be either way, depending on the plan that's presented to you.
As long as it complies with the zoning, which is 35 feet for a height
Right.
restriction, which is applied
Yeah,
throughout the
I know
town.
that.
Yeah,
Right, and then the units would be limited based on the acre,
right,
the acreage.
right.
You'd said we have to find this consistent with our comprehensive plan of conservation and development. I'm not sure I exactly understood that. what you're
When you get
saying.
to the point where, assuming that you've passed the regulation and somebody comes in to locate it somewhere.
Oh, okay.
This, no, because it's
Yeah,
not
okay,
located
that's-
anywhere.
That's what I thought you were trying to state.
Yeah.
So, to that point, so this is the proposed land use map that's taken from the Plan of Conservation and Development. So if you look at the parcel by the ice rink, that is actually, notated as industrial park, I believe is the same. I mean, it's the same color as whatever Honeywell or Firelight is and the ice rink. I know that
So that's not an R40 zone, is that?
currently it is.
Yeah.
But this is right, proposed land use shows it as being something different. I think that's why initially the thinking was this, a more dense residential use, if that was of interest to the Planning and Zoning Commission, it would be a good transitional zone, because you're going from industrial to residential. Similarly, if you look down at, say, like 50 Fowler Road, which is also zoned I3, that's actually listed as multifamily residential. Same as Evergreen Woods, which is also zoned I3.
And how big is Fowler?
90 acres, or 89.25 or something.
Like 270 units.
And so they were actually interested in this regulation and the possibility of if this could fit, because they're looking at the demand and the housing, and because they've done a development in Orange where it was individual units as opposed to larger buildings with 50 or more units per building. So it's something that I've been looking at and I've been thinking about, because when you do the math, 6 units per acre, 89 acres, you're up in the 400 units. Just pure math,
Right.
not looking at the
Yeah.
other possibilities of topography and utilities, because that's another thing that we had talked about at previous meetings. One of the things in the regulations, it says that there has to be sewer and water available, or East Shore Health has to sign off. Now, the commission could look at that and say that water and sewer have to be available, if that's something that is of interest, if you wanna narrow down.
Is the
I honestly don't
ice
think-
rinks
No.
sewer, right? Sewer and water.
Both, I believe. The ice rink has both.
I don't think that you can
Correct.
incorporate that, making sewers and water a demand for the regulation.
Why not?
Because,
Why do you-
well, because the town is really fighting to get water and sewers every place, you
Right.
know? So,
Business.
for business, yeah, for everything.
So I don't know if you're interested in looking at that, just, the white areas are single-family residential. I don't know if you could, if there was a good enough development, if you could argue that the cluster, it's still single-family, they're just clustered. It's the type of development, the development style.
One of the questions I have, while looking at that, is when you say unit, what constitutes a unit?
Well, a dwelling unit, it could be a single-family house, it could be an apartment in a multifamily building.
So if I had, so I could either have 6 single-family units or 6 duplexes on the same acre.
You'd have to have 3 duplexes, because a duplex
Okay,
would
so a
be 2
unit
units.
is what we're gonna
One
call.
dwelling unit,
One dwelling unit.
yeah.
But that, it could be, if the dwelling unit is a kitchen, dining area, living area, bathroom, and bedroom, under your scenario, it could be one on every story, right?
It could
Well,
be.
They can only have 3 units.
only have 2.
If it was a duplex, you can only have 3 units.
3
Three duplexes.
yeah,
Right, so you
Yeah.
can only have 6 dwellings per acre, no matter if it's, if you could, let's say you had a, I don't even know how to say it, but a triplex.
Yeah.
You can only have 2 of them on that acre. You can only have 2 of
6.
those 3-family house, or, units.
6
So
dwelling
6
units
dwellings,
per acre.
6 dwelling units,
Density
Dwelling
per
unit
acre,
meaning
it
your-
says 6 units.
right,
Yes.
dwelling
6
units.
dwelling units.
Yeah, no matter, however they want it, yeah, single units are 6 of them, duplexes
Alright.
would be 3,
I
yeah.
gotcha.
but as Carrie suggested, something you might want to consider is putting a maximum size to the lot. You know, if in your thinking, it would be inconsistent with the way North Branford is developed, to have a development with 300-plus units, which would be allowed under this regulation. Maybe you want to put a maximum acreage, so minimum of 5, maximum of something or other, in order to avoid the huge kind of development that would otherwise be possible under this regulation.
The other thing, I'm looking at our current regulations under elderly developments, and it's not as clear cut as far as how many units per acre in this regulation. I'm just curious about your take on this, Attorney Whitney, but, so it says here for density, it talks about a minimum of 8,000 square feet per dwelling unit, and that's for an efficiency in one-bedroom dwelling unit, or for two-bedroom dwelling units, 9,500 square feet per dwelling unit. And then they talk about a nursing home bed, but it's different because this really talks about kind of care facilities. But I'm wondering if that's something to look at or consider.
You mean the size of the dwelling units?
Right, having a minimum square footage per dwelling unit as opposed to the units per acre. I don't know if there's a benefit to that or not. Or if it changes it.
You know, from a developer standpoint, and I'm guessing here, I suspect a developer would prefer the flexibility of simply saying 6 units, and then they can decide whether there's a market for 1-bedroom or 2-bedroom or, you know, whatever.
Yeah, but that would have an effect on the parking spaces. Because if this is based off of a dwelling unit with 1 bedroom versus 2, if you have 2 bedrooms, most likely, well, I'm not gonna say most likely, but the potential of people, the residents having multiple cars. So the parking spaces would have to be adjusted based on whether it's 1 bedroom or 2 bedroom. If we had that flexibility.
But you already accommodate that with the garage and the
No,
driveway
but I mean,
being 2 spaces.
but if
for
they're
2
basing,
cars.
if they're basing this dwelling, this unit,
Yeah,
off of 1 bedroom, that means if you have 2 bedroom, you would
would have,
probably
what,
need.
3 cars?
No, but I'm saying, no, but that's, if this is based on 1.
That would have
Yeah,
to.
but it also says that you have your garage and your
I
driveway
understand that.
are 2.
Yeah.
So most couples now, unless they're really, really old, have 2 cars.
Right.
One in the driveway and one in the garage.
But if they weren't anticipating that when they put this regulation together, if the dwelling is based on 1 bedroom, and they're saying the parking spaces are based on 1, maybe 2 people being there, or potentially more, because you have 2 bedrooms, it might, and I just said it may have effect on the parking.
But
So-
maybe not more, depending on how you define the residence.
Well, that's what I'm saying, it has to be clearly defined in here, because, I mean, what we're doing is, it's not, so.
Well, the way it is now, it presupposes simply one resident 55 years or older, and that person's spouse or partner. And it doesn't go beyond that.
Right.
Now, if that large, more complicated proposal for age restricted that I gave you does allow something beyond that.
Right.
And I don't know if you want, you know, if you're interested in going into that much detail or not.
We'll have to take a look at that, but, yeah, if it does, then, like you said, it have to be some of this would have to be readjusted.
Possibly, yep.
Kira, do you have any, did we just have the one referral, or?
Yes, I'll just read that into the record. Basically what Attorney Whitney had mentioned. So this is the referral that was sent to the South Central Connecticut Regional Planning Commission. Thank you for sharing the proposed zoning regulation amendments. The RPC reviewed the proposal at its meeting on Thursday, September 10th. By resolution, the RPC has determined that depending on the location of the proposed age-restricted housing district, there is a possibility of municipal impacts. The Commission should consider clarifying the provisions pertaining to the density calculation, potential size of development, and whether the proposed provisions pertaining to the set-aside open space requirements are appropriate. Sincerely, James Gouletti.
That's kind of what we're talking about in a nutshell. There's so many, this just needs a lot of consideration.
Absolutely.
And there's just too many maybe loopholes, and just have to be careful about what we pass and what can come down the road later.
So if there's nothing else, I'd like to, could open it to the public at this time. Would anybody like to speak on this public hearing? So, being that, we received this, and we have some of the other, the proposal, so we'd like to, continue this public hearing, we're gonna leave it open, so we have a chance, as Fran said, to really take a look at this, scope this out, and then, we come back in 2 weeks at the October 17th? meeting?
15th.
15th, yeah. The October 15th meeting, and we'll
Fine.
take it up again at that time.
Okay, thank you.
Thank you.
Thank you.
Can I just say one thing to be considered? Did you close it? Is that it?
No, I didn't close anything, no.
When you talked
I didn't
about
know.
like Fowler Road, that bigger
Parcel.
parcel, most of those usually incorporate other amenities, usually there's clubhouses and there's all
Yes.
different
Right,
things
yeah.
in dining, in-house dining and things like that. So it's a whole different scenario
Exactly,
there.
yeah.
But bear in mind that at the moment, this could apply to a much larger piece of
I
property.
was just,
Yeah, that's- yeah, we're- yeah.
talking, they were talking about maybe making it lower, and I said,
Yeah.
that was my reason.
That's one of the things we'll probably do next time. We'll probably work with Gary just to see what the effect, the net
Fine.
effect is on the properties.
Just on one other thing I just wanted to know, you had mentioned, a variance for going that route, and
Well, a change in this.
so if there was a specific parcel and they were looking to do a development, a variance I think would be very difficult, and I don't think that it would be the right tool unless there were unique conditions to that
what
parcel,
about-
because the hardship would be very challenging to.
What
to
about
prove.
a zoning change? If the front piece is, that's what I meant, not a variance. If they change it to industrial, well, that makes a bigger difference. Because now it doesn't apply to every 5-acre parcel in town. That's all I was trying to
Yeah.
bring out.
So, okay, so change that to industrial.
It's
hard,
only,
that's
if it's a possibility,
Generally.
But
I
and
would be
then- and
much
then-
more in agreement with the regulation as it stands today, as it's presented to us today, because of the fact that we're leaving it open to, and I know you can put all kinds of, when it comes in for this, that, and the other thing, but you're gonna have a can of worms opened up for a lot of areas that are 5-6 acres to put this in, thinking that, hey, rather than, I'm in a 2-acre zone lot, but I've got 4 acres, I've never divided it, so rather than put 2 houses in, that maybe it's at the end of a cul-de-sac or end of a street, let me put up a
Yeah.
multiple housing unit.
Yeah, we'll look.
We could discuss that at the next meeting, but thank
Okay,
you.
thank you.
All right. So. I erred. Yeah. I was testing everybody and nobody caught me, so I erred. It was your test, it was a test tape though.
Weird.
No, yeah, what I did was,
You
I
didn't
went
go
out of
to
order.
Possible actions.
yeah, what I did was.
Carrie tried to correct you, but you didn't listen.
I didn't, you tried?
She did early
you really?
on.
No, well, I actually didn't catch it.
Oh, okay.
I just mentioned the
So-
motion.
Just, so our next order of business is possible action of public hearings. The first one was application 2015-7. We had the public hearing, we closed it, and we acted on it. So that one was completed and that was passed. The other two items will be, the public hearings remain open to our next meeting.
Do you wanna,
Isn't
do
it,
you guys usually vote to continue it? Or just, they're just continued?
I don't remember
I
voting
I don't
on
think,
it.
I think, yeah.
We just.
the
continued.
2015-7
We voted
is
on it.
extended, it's not closed.
Oh, I'm sorry, which one did I say? Oh, I'm
You
sorry.
said 2015-7.
2015-8 was acted upon and voted.
Right.
Yeah.
Oh.
So we're on to, Old business, which is still at the state. New business. Revision to PZ application 2015-9.
For the record, I'm Mark Young. I'm a land surveyor with Baldwin Associates. I'm representing Al Facilio, the owner of Facilio's Pizza, which is now under construction. The site plan you approved last time was, I don't have a copy of it, but it basically, that plan was fully compliant with the regulation, with a reduced seating area, which reduced the parking requirement, which made us, allowed us to make a compliant plan. Since then, we have applied to the Zoning Board of Appeals for variances. Find the right plan here. Let's see, yeah, that's the second plan. And let's see, here we are. Okay, we applied for a number of variances. Let me just go through them quickly. We variance for the number of parking spaces. 27 is required for the proposed seating area. We have 24. Parking setback to the street line, whereas 10 feet was required. In order to make this work, the setback is 0. Also, setback for parking from a residential district boundary line, regulation is 50 feet. We're granted a variance to 13 feet to allow this configuration. The dumpster setback to the street line was 10 feet, is varied to 2 feet, and to the residential district boundary line was 50 feet, reduced to 15 feet. Impervious cover, the regulation is 80%. We have 82.3%, and that was approved. And the sign, the height, because this is actually in the parking area, we needed to have a higher sign, whereas 144 inches is allowed. We were granted a variance to 170 inches. Also, the sign setback to the street line from 10 feet and to 0 feet. So, with all these variances, we have this site plan which allows the full dining room, and I think this configuration will work well. The big advantage here is we're going to cut off this entrance, which will improve the traffic flow down Merrick Drive.
So you have two entrances on Foxton Road, correct?
Yes, we're not going to touch anything out here. That's in the state right of way.
Right.
And basically, we don't want to deal with that.
And then you have the one exit onto
There's
Merrick
one
Drive.
here, yeah.
Is it entrance or exit on Merrick Drive?
This is actually both.
Okay.
But we're going to specify one-way traffic down here because of diagonal parking, and it's a somewhat limited aisle here. This will be the entrance and exit here, but for these parking spaces, it will be one way here and out here. And these parking spaces will come in and out from here.
So I remember this sign setback variance. What was the reasoning of the height from 140 to 170?
Because it's actually right on the edge of the traffic aisle. We wanted to have it high enough so there wasn't a clearance issue,
So
with
it's
trucks and
just-
vans and so forth.
So it's just elevated up so you can see under it?
And also sightline.
There was discussion at the ZBA meeting because of like box trucks being a certain height, and if the entire height of the sign is at 12 feet, that's to the top of the sign, but the sign itself was something like 5 feet or 7 feet?
5 feet.
5 feet?
5 feet, right.
So a 7-foot clearance was questionable for a truck, is how the discussion went.
So all the buffers you showed us before, the fencing remains the same?
Okay, yeah, be a fence all the way around it. We're gonna leave the existing pine trees, some mature pine trees here. There's some row of arborvitaes here, which will remain.
And then since you now were able to move the waste container to the
Yeah.
front, is that gonna be protected or
Yeah,
surrounded?
there'll be a solid fence around that. It'll be like, I think, like a chain link with slats in it. This will be a white plastic board fence.
Right.
It's really not practical around the dumpster because it's kind of fragile. So that's why we'll have, metal fence around the dumpster. And we put it out here, consideration for the neighbor, so it's as far as we can get from his house. Also, too, it has to be at least 20 feet, I believe, from the building for fire regulations. But it'll be screened there, so I don't think it'll be particularly intrusive.
Do we have any, did we receive any referrals or anything part of this, since it was already, probably don't, correct?
Right, so we don't.
Right.
But the changes have been addressed, or the concerns have been addressed. So just to reiterate, the town engineer had concerns because the parking extended over the property line along Merrick Drive.
Right, we've set the
Pushed it back.
parking edge right on, the new curb will be right at the street line. So
Just to, I don't know, just to expand on that a little bit, the existing island is in a dashed line, so that's existing. I only point that out because the curb has been there for at least 10 years, probably going back more like to 40 or
Well,
50 years.
I-
I don't, maybe not that long, but.
Kurt indicated, because the existing curb was right along here, like that. Kurt indicated that it wasn't that long ago, I don't know, 10 years ago, that this was all open. And they actually put that curb in to define the parking lot. So, that actually hasn't been there that long, but, it's really an improvement in traffic flow.
There is a version of the plan that instead of having those 8 spaces angled, they're going straight in to that curb, which would give that line, I believe, 10 spaces as opposed to the 8.
There would be more spaces, I don't have that number in front of me.
Right. So I only mention that because Mr. Pacilio is looking to pursue talking with the town council about getting an easement onto that, I think it's 3 feet or something, over onto town property, which, wouldn't encroach on Merrick any more than it already is, but it would allow him to have parking spaces that go straight in to the curb, and that would reduce the number of parking that are against the building. So you see one spot against the building and then one in the.
Oh, so
Would-
we go from,
Would you change the flow, the one-way? It's one way there.
Yeah,
Would that change?
So we'd be able to.
Do two-way? Because I think that one-way is impractical, but
Yeah, I know, definitely.
it's not gonna, you can say it's one-way, no one's, if you give them
Well,
if you
you
give them
put
the
signs
ability to
everywhere,
go in, they're going.
People are gonna do it.
Yeah,
Excuse me.
at least.
Sure. Dirk Goss, Waldo and Associates. One key point, though, is that the town is only likely to grant Al a temporary easement, temporary median, for some reason they want to widen the street, or whatever.
Yeah,
So it's
sure.
important that we show a feasible plan.
Right.
Oh, yeah, no, I know, yeah,
Right.
yeah.
The marbles we
No,
have
I
to-
understand that, yeah. No, I'm saying, I'm kind of supporting that would, because I'm looking, when you say one way, I'm saying, no one's ever gonna do that. And I'm envisioning myself trying to back out while someone's coming in the way they're not supposed to come in.
Yeah,
So by getting a temporary easement, that will
It would
help
help
that.
a lot.
That
So
will
we'll be
help,
back
yeah.
in front of you with that, hopefully.
Is
It's
it,
not practical.
but that's not in place
yeah, I
yet.
don't think they have to come back.
wouldn't that go along with you getting more spaces so that you could increase the inside eating area?
Well,
You're too shy of
we're
the,
still short.
yeah,
It's
You know,
too
we're-
shy anyway.
we're we're still operating under the variance. So, we just, even with that, we still can't increase the parking enough to increase the
No.
seating area.
Okay.
Right.
Excuse me, the seating in the dining room can't be increased anymore.
Okay.
We're at our max. That's it.
Yep.
So one other comment, just, the one parking space that's against the building,
That was back here.
the one actually closer to Merrick,
Oh, here.
would it be possible to even have temporary or short-term parking in front of the dumpster? Just because that location specifically seems like it
Well, that
is
will,
a hazard.
that will be utilized. There's space there and actually, and I did count it. So that will be utilized.
Okay.
You know, the thinking being that, you know, the garbage man comes in the morning
Right.
and nobody's gonna be parked there in the morning.
Right.
So
Right.
I
But
don't
just
think
because
there'll
the
be
one
conflict.
directly against the building there
Yeah.
is, you know, it seems like a challenging location if people
Well,
are backing out and.
it is tough, but you know, when the parking lot's full and somebody's coming in to pick up the pizza, you know, they can pull in there, park for 5 minutes and leave. You know,
Would
it's-
any of them be signed kind of takeout only or?
No.
Okay.
You know,
They
people,
won't follow that.
like you said, people aren't gonna obey the signs. They're gonna park where there's a parking place.
Sure.
You know, hopefully, you know, you know, I have seen, some restaurants and pizza places with signs that are posted, you know, takeout, parking only, 15 minutes or something. But, I don't know how, some people pay attention to that. I'm sure some don't.
I mean, the one thing, Bill, is, anything you could do is identify somebody making a right, coming on, right off of Merrick, because that could make it very difficult.
We mean,
Yeah, if there's some way you can say, it's something that you state, you know, do not enter, you know, because if you have cars coming from Fox and there's a full parking lot, you're kinda stuck there,
They can
so.
go in and out from Merrick.
No, what I'm saying is
Just
the car.
in the center there, it's a one-way.
That's
You
what
can
I
go
mean.
in and out the front, in and out here, but here you
Well,
can't.
so
Right.
could you go in it if it's only one way?
No,
It's
you,
only,
Well,
it's only
you know-
within the parking lot, it's one way.
because
Not,
Merrick.
not in the
Right.
entrances.
No,
From Merrick.
All I was just suggesting is that when you enter, since it's one way going right to left, you make sure, you at least identify cars that they can't make a right when they pull into Merrick Drive, that's all.
Yeah,
I'm
that
just,
could be done
anything you
with-
can do to identify, whether maybe even paint on the pavement, because if you have cars coming the one way off of Foxton Road, and you have somebody coming the other way, and you have a full parking lot, you have an issue. So I'm just,
We
this
could-
is a
The best thing
suggestion.
is if you can get
You
this
could post a
temporary
sign.
variance.
Yeah.
Get the temporary variance and change the parking.
Don't they have the
Yeah,
spikes
when we
that if you
change
go,
it, going
don't-
back to 2 ways every day.
Exactly, yeah.
they don't have the spikes that are pointing the wrong way, so if you're going this way, you blow your tire, and this way, you just run and they go down?
Not yet.
Just a thought.
But all those entrances are wide enough right
Yeah.
now for 2-way.
Okay.
And when we go back to the original plan, everything will be 2-way.
Yeah.
Right.
Because like you say, people are gonna drive where they
Yeah.
want to, especially if they're hungry.
So the fire marshal's concerns, as you mentioned, you know, included the dumpster, which has been addressed, and then he was okay only having access to 2 sides of the building, although he said he preferred 3, so this provides that
Right,
third.
this provides, access to, you know, full access to three sides and part of the 4th side.
Right.
So, there's plenty of room for the fire trucks.
And then the Regional Water Authority had submitted a letter as part of the most recent variance application, which was of this plan, and they had no issue. And East Shore Health, I don't know if you want to speak to that, there's been a updated
Well,
septic plan.
we did revise the site plan. I can't recall exactly the timing. Kings Light, there's a well over here. Originally, we had the septic back here where the existing septic was. Turns out that was actually in violation of the 75-foot well setback. So we revised the septic system to fit in here, and that's been approved. It's very good soil there. I mean, you could have a septic system a quarter of that size and it would be fine, but that meets the code.
The other thing that I've been talking with Mr. Basilio about is the landscaping. So Mr. Young mentioned that there's currently arborvitae that exist right in between 285 Foxen Road and the existing gas station. I looked at the site plan approval for the gas station on the corner, and Carol had worked with the applicant and the property owner to install 8 arborvitae there. I wanted to ask the commission, kind of your thoughts. I believe that the plan is to put a fence up and keep the arborvitae there, but put the fence obviously on his property, so it would be on the eastern side of the arborvitae.
This,
Right?
on his
Southern
side,
side?
yeah.
Easter.
Eastern side.
Eastern side, yeah.
Because one question was, should the arborvitae come down? But I think that after seeing it on site, I would recommend anyway that they stay there. I don't know if it would end up turning the fence, moldy or have some growth on there. But Mr. Pasilio's plan is to have a patio also in that area in between the fence and the building. So I think it would provide just a little bit
Yeah.
of screening at the top,
Yeah.
because you can see the gas station awning.
Yeah, but the arborvitae's are on the gas station property, right?
Yes,
Yeah.
yes. And then that's just a photo of the pine tree at the front of the building.
I think
It's
those-
on
Just
Merrick,
there.
not on the front of the building, it's on Merrick, towards the rear. Unfortunately, a lot of those trees and even the arborvitae had a lot of bittersweet and other vines growing through them, so that's why those limbs were cut down according to Mr. Pasilio. So, and then this is just, I took a Google Street image of Mr. Pasilio's restaurant in Branford, and those are some of the gardens that are there.
Good.
And then, the signs were not approved under the last, application. So I just wanted to bring your attention to that. So the variances were approved for the height, but this is the design. It would be on both sides, correct? And then there's 2 wall signs, which also, meet the regulations. And they would be, it says on here, internally lit channel letters. So I have the sign permit application for, all 3 of those signs.
I think we're good. Do you have a motion for that? or-
Yes. I have a motion for everything.
All in one?
Yep. Yep, because we have to cite the revised plans. I think that's it. I don't know if you guys have any other questions.
Nope, I don't. Have any other questions? No? Oh, paper, that's for sure. Yeah, yep.
So in the motion that I drafted, I didn't change any of the conditions. I just changed the plans that are cited,
Oh,
just because they're revised to September 21st.
Right, and special condition 22. Right?
That was in the other one. That was in the original one.
Oh, so we don't need it. Yes, we do.
We can keep it, right?
Yeah. you can keep it.
Really, the only change in the revision is the approval, the plans
Yeah.
and the dates. It was September 21st for each of these, and then the septic plan and the signs.
Somebody's gonna tell you the story about.
Yeah, read everything except not the standard conditions, but just.
Just cite those and then read 22. You have to read, unless you wanna read the whole thing. I mean, we have plenty of time to, I'm not gonna.
That's all right.
I'll stay here.
I move to approve revised application 2015-9, site development plan under section 23, Schedule A, line C-5, for reconstruction of an existing restaurant, associated parking, and landscaping at 285 Foxen Road, Assessor Map 15, Lot 76, Zone B1, owner applicant Albert Basilio, as described in the revised site plan documents and shown on entitled maps. Site plan, property of Albert H. Basilio, 285 Foxen Road, North Branford, Connecticut, prepared by Waldo and Associates LLC. Date June 15, 2015, revised to September 21st, 2015. Parking, scale 1 inch equals 10 feet.
Second bullet, site plan, property of Albert H. Pacilio, septic system repair, 285 Foxen Road, North Branford, Connecticut, prepared by Waldo and Associates LLC, date August 15, 2015, revised to September 21st, 2015. Moved gallon, is that it? Moved
Galleries.
Moved galleries, thank you. Scale 1 inch equals 10 feet. Bullet 3, construction drawings, Pacilios, Beats, and Pasta, 285 Foxen Road, North Branford, Connecticut. Schedules and left side elevation, front elevation, right side elevation, and rear elevation. Scale 1/4 inch equals 1 foot. Prepared by Plans Ahead LLC, dated June 3rd, 2015, revised to September 21st, 2015, sheet 1 of 3. Bullet 4, construction drawings, Pacilios, a Beats, and a Pizza, 285 Foxen Road, North Branford, Connecticut. Foundation plan and ground floor plan, scale 1/4 inch equals 1 foot. Prepared by Plans Ahead LLC, dated June 3rd, 2015, revised to September 21st, 2015, sheet 2 of 3. Bullet 5, construction drawings, Pacilios, Abits, and Pasta, 285 Foxen Road, North Branford, Connecticut. Roofing, framing plan, and section through, scale 1/4 inch equals 1 foot. Prepared by Plans Ahead LLC, dated July 20th, 2015, revised to September 21st, 2015, sheet 3 of 3. Bullet 6, Pacilios, Abits, and Pasta, street sign, prepared by the Reflected Image Signs and Design, dated September 18th, 2015. Last bullet, Pacilios, Abits, and Pizza, Abits, and Pasta, building signs prepared by the Reflected Image Signs and Designs, dated September 18th, 2015, with the following conditions. Following standard conditions 2, 4, 7, 9, 10, 14, 15, 19, and special condition 22, which is coordinate with DOT to complete any permits needed for items within the state's rights of way.
Is there a second?
Seconded.
Is there any discussion? There you go. You know, we already passed it the first time without these revisions, but, so all in favor?
Aye.
Any opposed? No? That passes 3-0. Thank you.
Thank you.
Good luck.
We'll see you again.
Thank you.
We'll become old friends.
Thanks.
All right.
Okay, next one is pretty quick. Do you wanna, I don't know if you wanna amend the agenda so that, Mr. Delvecchio can go. This is just under,
Oh, what's-
other
Oh,
and, under the planner's report, and then we can do the approval of the final
Oh.
subdivision just last.
I move to amend the agenda under B, other items, to allow for Don Delvecchio to speak.
second, Fran? Yep. All in favor? Yep.
Aye.
Aye.
I really didn't have much to say, just
Oh.
waiting to see what Carrie had to say, and if she was going to mention something about the brew-through. We're thinking about putting a brew-through in the gas station.
A what?
A brew-through, they're very popular down in North Carolina, where you drive your car through the center of night, you purchase alcohol. Now, they are popular down south, but you've probably never seen them, have you?
No, yeah, actually, there was one in East Haven.
Is it really?
There was.
I've only seen them in the Carolinas,
You
they're
know
called
where
brew-throughs,
There
yeah.
used to be
The law
on
firm there.
Frontage Road.
Yeah.
Oh,
Yeah,
really?
right.
Where is it, in East Haven?
No, it's not there anymore, I don't think.
No, law firm's there now.
Okay. It used to be,
yeah,
it used to be the old bank.
For a long time,
On Frontage
years.
Road, when you were going towards Branford from East Haven on the right-hand side, it used to be a bank, and then there was two
Not that
banks.
host-
And then
hotel.
when
I
they
never
did-
saw one in
Yeah,
Connecticut, I've seen
Howard
them down
Johnson.
south, they're very popular in the
Yeah,
Carolinas.
drive-up window, that was like 20 years ago.
Yeah, but this one, you drive right through the building down in the
Oh, here, you
Carolinas.
just drive up to the
This is
window.
their,
No, you drive right through the building,
I've seen,
yeah.
I've seen.
You don't have to be
North.
formal, because we're just having discussions. You can come up here and kind of, we have.
This is the, we haven't done anything with it other than the site plan. My concern is that I don't believe I need to come to you for a site plan approval, because everything that you should be concerned about on a site plan approval, if we convert this to a convenience store, the gas
So
station.
I don't know if
Yeah,
you wanna
that's
back
what
up,
it is,
right?
Gas station or convenience store?
Yeah.
So
and,
this is,
but I don't-
you know where this is, right?
Yeah.
So this is 847, so Dunkin' Donuts, Subway, and the tobacco store exist, and then there's a gas station that exists.
Right, so we're thinking of converting this to a convenience store, and I don't believe I need to come before you for site plan approval, because we have the parking, we have the lighting, signage, none of that is changing. We meet all those requirements. I think the only thing I need to do is come before you for architectural drawings, because you're in that design.
Well, that would still be sort of the site plan
You
too.
gonna keep
Joe.
the gas?
Yeah, we have
Yeah,
to
keep the gas.
the
Yeah,
gas,
right,
you know,
yeah.
we have to keep
Yep.
the gas. And, but I'd still like the brew-through, but I know Fran won't go for it.
I'm not the last
Now
word.
you mentioned brew-through, I mean, that's
Right.
different.
So, right, so in talking with
But the center
the,
base work out perfect. You
Yeah.
just drive right through, we can open it up, and you
Get your
exit
coffee,
back
get your
and
beer,
get your beer.
get a sandwich.
so yes, in talking with the zoning enforcement officer, there's the Northford Design District.
Right. You know,
So, which was, very helpful.
Yeah, yeah.
Yeah, this is
You
where
know,
the
all
driveway
architectural
is,
designs
the
must be
drive-through.
approved by Planning and Zoning Commission.
And this is the
And we
gas
also
station.
submit them to the
Just
design
wanna
district,
change it
there's
to
a couple
convenience.
of people in that
This is
design
gas, this is convenience store.
district, something, there's a couple, I can't remember, was it Steve? I don't know who it is. It's been a while since we had to submit some, who's on the design that we run past, is it Steve? I'm drawing a blank.
Sabo.
I can't
So it
remember.
does say here,
He's on planning, he's on the town council.
Yeah, but
did you see
there's a-
that
What's
one?
that?
So under,
He's a landscape guy, right?
what you were saying, Harry, so all plans for
Read
new
it.
construction, reconstruction, renovations, additions, and or site improvements shall be in accordance with the design district plan. So that's where it just says site development plan.
But there would be nothing on this plan that would change, that's my argument. So the
Mm.
site plan wouldn't change, what you guys need to see is an architectural drawing of the building. That's really what you're
Right, and
focused
the
on.
parking numbers actually would go down, so I just did some calculations based on the assessor's card. This building is 1,595 square feet, and based on the parking requirements, it's 11 parking spaces.
Why would it go down?
Because for a gas station, you need 5 parking spaces per
But you said he's keeping the
garage
units.
bay.
But he's
No,
keeping.
the service station, where, see, they need.
Oh, I
for
got you,
each
I got you.
phase
Yeah,
is
yeah, yeah,
5,
yeah, yeah.
You have to demonstrate 5.
Wow.
Yeah.
So he's not gonna have the service bay anymore.
No, we can't, what's happening is the town, take a guess at what they're assessing us at the gas station, just take a wild guess
Right.
per acre. Take a guess, take a
I
guess,
have no idea. I don't even know.
just shy of 1.2 million. That's what I said, that's why this, it's forcing this issue, because what has to happen, that's why all the service stations went out of business. You have to sell fuel, if you're gonna be in the business of selling fuel, and you're gonna be taxed at almost $1.2 million an acre, you know, what they do is they obviously say, okay, we're gonna assume that you're only on a third of an acre, but still, it jacks
Right.
up your assessment significantly, and that's something they did 5 years ago. We tried to, fight that, but they're, I don't know, they, like any other town, they need money, so this is what they did.
Is that town or statewide?
Yeah, they
This
drive
is
the
the town
business
that
out
does.
by increasing the taxes on it, but some of the businesses are paying exorbitant taxes.
But this one, like you say, they came up with this new assessment out of the blue 5 years ago, almost just shy of 1.2 million an acre.
The only reason I gotta think about this is because,
We need to sell fuel, so what's gonna happen?
no, I'm just saying, as far as
Yeah.
what distinguishes between maybe and maybe not site plans, because we are affecting the traffic. There is an additional traffic flow, and that's,
Based upon
well,
the use?
yeah. If you're
Yeah,
driving straight through.
I'm not sure that,
I mean, that's just, we understand, I mean, we'll just have to look a little more into
Yeah,
it,
yeah.
because if you're driving straight through, if that's what you mean by a bay,
what do you mean you're driving straight through,
or
Gary?
you called it a
No,
brew-through.
No,
it's
I-
kidding,
I-
it's
no,
just
no,
convenience
no.
store.
He's only
No,
I'd
kidding.
like to put a
It's gonna be a-
brew-through.
No, no,
Convenience store.
Yeah, it's gonna be.
convenience
I'd
store.
like, I'd love to
What
do
are
it, but I
these
can't-
3 spots right here?
That's his
Those are the
existing.
bays, so what's
That's
gonna
right,
happen,
those
the
are
big
bays.
doors are gonna be.
Those are going away.
They're going away, they're gonna be.
And these
windows.
make
I
them a
thought
Going
convenience.
to
I'd love to
convenience
do
store.
the brew-through, if you're.
I
I
think
know,
they
you
need
can't,
that.
you can't joke at 9:20
I'm
at
saying,
night.
okay, I'm looking, I'm saying, all right.
I'd
And you
love
said you
to
could,
do
and then
it.
you came up and you said you could
Yeah, I
drive
got you,
through
right,
to
right, right.
for the coffee. I'm like,
just saying,
okay.
it wouldn't work.
I
It
gotcha.
wouldn't work, and if I
I
could get
gotcha.
your vote, I mean, I would,
Okay,
I could show
So you
you
just-
some nice pictures from
okay.
the Carolinas.
so what exactly, we're.
Convenience store.
Okay,
It's a
Yeah.
convenience store.
This stays here, this is a convenience store.
yeah,
Although, to your point, I don't know if that, is increased traffic though, no? I mean,
Well,
be more.
We're gonna be
Yeah.
open later at night, but, as far as the volume.
And
is
where, in the
concerned,
parking for the convenience store?
What do you think?
You
I
had
mean,
to
It's
be
less.
300, it has to be within 300
Not me.
feet of the, building, and we have it on site. We have how many spots do we
It
have?
seems like
59?
it's a change, I don't know what the rules are, but it,
Well, so, you heard the rules regarding
Well,
architecture.
let me, but I wanted to stop and go back to, we got the right architecture. When
So-
Wall changed his from a service station to a convenience store, he came in, he had to come in front of us and, right?
Sorry, say that again?
the Northford, or the.
Route 17, Wall
Yeah.
had the, service station, then it should change that to convenience store. So he had to do a site plan.
It was
Okay.
architectural
so-
though,
Okay.
But,
and that's,
I
yeah.
can look, I can pull that file.
Yeah,
I don't
we-
think he had a current site plan.
What's the
on it. This
address?
is a current site plan.
Do you know
This
what
one was
the-
approved by you guys, we got all the parking, I don't think he had any of that.
all he was
That's
doing was
17.
changing the use.
But he never had a current approved site
It was
plan, that's
called
different
Walt, so
in
it
our
was
case.
part-
Yeah,
was
so
parking-
we'll just look at that.
Parkview.
Either way, we'll get back to you on
Because
that.
we-
Yeah.
His name was Walt, but it
Yeah.
was Parkview.
Yes,
Parkview,
Yeah.
yeah. But we'll just have to look, because if we, we just wanna make sure that everybody's on the.
So under change of use, which is in our regulations, it says a change in use of land or in the use of a structure or building will require commission approval of a site plan if such change in use increases the required amount of parking, loading, or access, or requires substantial alteration to the land, structure, or building. Minor changes in the use or occupancy of land, structures, or buildings not requiring additional parking, loading, or access will not require site plan
Well,
approval.
is this major or minor changes in the
The
building
building, the
itself?
building exterior is not changing, other than
Right.
siding and glass windows. The
It-
interior, you guys can't, it's retail use.
And parking's going down, not going
Yeah,
up.
It's going
parking's
down.
going down, so
Yeah.
it probably
So-
doesn't need a site plan.
Yeah.
Like he does.
But
It
I don't
doesn't-
think it needs the architectural because of the
Right.
design district.
Yeah, I agree with that part, yeah.
But that's my take on it, but I wanna make sure we're all clear on it
Yeah.
before we, do it.
And then
You-
when you do the architectural, if you could just also speak to the sign, you don't have to right now, but if the
On the
sign would be
building?
changing building and or in
They
the
may fly-
island there.
They may fly a different flag, I don't know if it'll be mobile, shell, maybe
Right.
off-brand, I don't know,
Right,
whatever
Okay.
they decide to do.
right.
And,
Well, isn't mobile across the street?
that they may be changing.
Oh,
to
really?
shell.
So what I'll just have to figure out
Right, they
is,
are. I'm sorry.
Couldn't
I
find
just
any oil in
remembered
the
everything.
Arctic.
I'll just have to figure out, a fee, how that, which fee is applied and if,
The highest one.
zoning,
1.3
would a zoning
1.3.
permit be
You
allowed,
charge
be
me-
required? I'll talk with the zoning
I'll
enforcement
pay
officer about
1.2
that.
million if you give me the Bruce room. But,
Okay.
All right.
And then we'll, all right, and then
All
we'll
right.
just, go on that. All right. so
Great,
you-
thank you.
Someone will get back to me then on that, Gary, I
Yes.
suppose?
Yes.
All right, thank you, guys.
Thank you.
Thanks, Tom. All right, let's
All right,
Okay.
finish this
we're
up.
rolling with Rolling Meadows next. So, I forget about TV.
Yeah.
I'll be getting a text tomorrow. You a little punchy or a little tired?
You're gonna be in Texas tomorrow?
No, I said this
Gonna
is
be getting-
replaying. So,
Yeah, I was gonna say, I think
Kind
you
of
have night
forget it
fast.
after a while.
yeah.
Okay, so this, you'll remember, back in May of 2014, right before I started. This is a subdivision that was approved by this commission. I think when, maybe this was Carol's last project.
Okay, so,
Oh, this one, yeah.
all right, so I
So
wasn't
Mill
here for this.
Mill
I'm
Road,
gonna need a- Oh, this is where they've
This
already
the
put a house
waterfall
in.
is?
This is where they put the one house up already.
yes, the
right?
one house
Okay.
is right here.
All right, gotcha.
Farm River, it's,
Yep.
we've got a.
The house has
open
sold,
space.
however, they can't finish the sale until the final, there was a, conditional approval that the commission made on the subdivision that's allowed per the statute, but they still need to file the final Mylar.
Okay.
So I'm just bringing this to you tonight to have you sign, I'm going to stamp it.
Oh,
Nothing's
okay.
changed, but I just wanted to give you an update because there are, so some requirements, it's probably easier to look at the other one. Pins were required to be set,
yeah. Well, that was a bolt on the border too.
here, I think this one.
Yeah.
So the
Yeah.
subdivision, the subdivision has not
dumb.
changed since the original approval. They're just finalizing it now so they can file it at the clerk's office.
So this one sold?
This one.
This one, yeah.
Yep. So this is the only one that's built. It's sold. Some of the conditions that still have to be done are just putting these trees in. The condition says that they will be staggered like this. The land trust will own this land. Their attorney is in the process of reviewing that deed. The land trust has been working with Ricky Construction regarding the plantings here. They have some feeling, and as does the owner of the home, they'd like to group these trees closer to the home so that this is screened and they have a little bit more privacy as opposed to just having a line, because with the topography change, they really don't need as many up here.
So what do they wanna do? They wanna,
They want to.
So, I remember some of this was so the land trust didn't have to
Right,
look
yeah.
at
right.
houses, not the house didn't have to look at the land trust. That was the whole point of this. So someone fishing
So-
down here doesn't have to say, oh,
But
God, look
a
at
lot
that.
of it was, and
Look at that, there's a
a lot of
car-
them was the encroachment on the,
Yeah,
this
yeah,
property.
on this,
right.
right.
And-
Kids
and-
come-
Because that was the whole
and you're-
discussion of boulders and all that
And you're
stuff.
defining what is the land
Yeah,
trust
exactly.
property and what is the homeowner's
Right,
property,
right.
yes. Okay, so that's one.
So this was the North Branford Land Conservation Trust has been working with a landscape architect and Ricky Construction and the property owner to come up with this plan. I didn't want to touch that tonight. I felt like it was too confusing. I'm just bringing this to your attention, because in order to sign the final Mylar, it's really about the 5 lots that were created.
Mhm.
6 lots. No, 5 lots.
It was 6.
Well, here's, lot 6. And then maybe this is the open space.
Oh, yeah, yeah.
So that hasn't changed.
Okay.
The pins are in. I have confirmation of that. Kurt's looked at this. Everything's okay. They do have to transfer the right-of-way to the town in
Yep.
2 locations. And our attorney is looking at that, but, Kurt is
So we can
okay.
sign this,
Yes.
all right, that's just something else.
That's something else because, again, our condition states specifically that the open space parcel shall be developed in accordance with the plan with the following modifications. Instead, 6-foot-tall white pines spaced 10 foot on center and staggered. No mix of pine types. So this was the revised plan as opposed to just straight in a line.
Okay.
And what I can relay to I just wanted to bring this up because the land trust has come to me and said, well, we don't really like this design, we wanna group them, and we wanna have hollies over here and cedars over here and blue spruce over here, and I said, okay, but let me check with them because they say specifically here, no mix of pine types. So, if they do anything in addition to this, maybe that's on them, but I think at a minimum, it seemed like from this is what you wanted.
I wasn't here
Is that
for that,
correct?
but if,
Yeah, I was.
but if,
I think the land trust was here,
right,
and they talked about,
I'm
they
sure we
didn't
can
want,
come up with that, I mean,
they
yeah.
wanted to have to look out and not have to see that.
Right.
So this was more there than us. I
Yeah,
think,
and
right? More
also,
them than us.
they wanted a definite
Yeah.
demarcation
Right.
from, so that people wouldn't start encroaching on their,
So if your place.
Land.
So, so let me ask you a question, this little design here, has that's the land trust, kinda likes it that way, right? And does the property owners okay that?
Apparently, yes.
Well, if they both okay about, I mean, I don't, it's the land trust and the
Yeah,
property owner's
That was
decision,
that was my
right?
point. This is the land trust that
Yeah,
dictated
I
this
mean-
more than
Okay.
we did. So
I
if
mean-
they're, for
So-
me, if they're happy with it.
One,
I kinda like
Doesn't
the
matter
idea
to
of
me.
mixing it.
Yeah,
I
I mean-
think they're the ones that specify
Okay.
that, not us.
And one thing that I was thinking is, whatever number of trees this is, I think it's something like maybe 28.
Yeah,
As long as the construction company or the developer purchases those trees, if they wanna group them all here or move them over, maybe as long as there's the number.
I would just.
well, it is, I mean, I wouldn't just say that, because
Yeah, I
then
think
they're
you
not
wanna-
following the
yeah,
plan,
you
but
wanna
if you
demarcate
say
it.
that, we approve that, the conservation is okay and the homeowner's
They're gonna,
okay,
no, I
fine.
mean, they would have to come
So
back and.
stick with this, if they wanna supplement and do anything more, that's up to
No,
them.
I'm saying, if they both agree on that, just do that.
Yeah, I mean,
Right.
But the
Yeah,
others-
that's what I say
Norway
too.
spruce, white spruce, some holly, some white pine. red
It
cedar.
Doesn't
Yeah.
matter to us
It would probably
because,
look-
Gotcha, as long as they mark the line,
Yeah.
But the only thing is, they have to come back, we have to change this.
right.
That's why I'm saying, this is the first time we've really, that I remember this really being that definitive.
right,
You know, specifying like exactly how many feet, sometimes it says will be set up with, you know, whatever it might be, so it's a little specific.
It was because this was the open space they were given
Yeah.
a land trust, and that was one of the conditions.
And I would-
They wanted
yeah.
to have a clear demarcation where they couldn't
Right.
see the homes.
it wasn't even seeing it,
because
but the
this is the
idea is
Greenway
that
concept.
they wanted to make sure that people didn't start moving
Yeah.
stuff into, you know, like they put a shed up, or it's a
Yeah.
little bit
Yeah.
over,
Or
or
swing
they
set.
mow it,
Swing set,
so,
yeah.
yeah,
So-
that was their whole plan.
So I think, if this is the land trust's suggestion, and they're agreed upon, you know, the property owner or the developer.
We'll have a
I th-
revision to
I
that.
think we need to have a revision, because if the land trust likes this, and the applicant likes it, then have them make the revision, so that we make sure
Okay,
that this is agreed upon by both parties.
okay.
Yep.
This is a motion just to approve this final subdivision map,
Right.
which again, this is just the Mylar showing the lots, which haven't changed since the original approval.
What? Okay, I just heard, yeah, I heard.
I'm up.
Yeah, okay.
Ready? I move to approve the final subdivision map associated with planning and zoning application 2013/14-10, Rolling Meadows subdivision, 65 Mill Road, dated January 9th, 2014. Assessor map 29, lot 4, R40 zone. Owners Henry P. Forte. It's all applicant developer Ricky Construction Group Incorporated, based on plan entitled Subdivision Map Final Approval of Lots, prepared by Ricky Construction, 65 Mill Road, North Branford, Connecticut, prepared by Malone and McBroom, scale 1 inch equals 50 feet, dated January 9th, 2014, sheet 101, and subject to the original conditions approved on May 15th, 2014.
Is there a second?
I second it, I just questioning if it's subject to the
I
original.
was thinking the same thing, yeah, how come?
You know, we're saying it's subject to our original,
That
so,
wasn't a condition.
This
was it?
this has nothing to do with it.
No,
The
is that a condition? We're saying it's subject.
to the previous conditions. Is that a condition, the white pines there?
Yes.
That's what I'm
Because so
saying,
but they'll have to come back and
Right,
change
so
that.
we're
So,
approving
okay.
it and
Yeah,
then
yeah,
come back.
that's
Then I
okay.
second
Yeah,
it.
Yep.
I thought the same
Any
thing.
other, well, we just discussed it, so beat me to that. All in favor?
Aye.
Aye. Any opposed? None. That passes 3-0. And then just let the land trust and the applicant know if they're agreed upon it, then we need to update and revise the site plan. All right.
Yes.
All right,
Okay.
good.
All right.
Make a motion, we adjourn.
No,
Oh,
no,
there's no more
we're-
business.
We're just getting started.
I thought we were
Oh, we
done.
are, I'm going.
Anything else?
I don't think so.
Oh, I just wanted to make sure. I wasn't sure. All right, go ahead now.
May I, sir?
I guess you-
Yeah, exactly.
Make a motion, we adjourn.
Donk.
All in favor?
Aye.
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 I second the motion
Yes.
too, by the way.